Well, isn't this a nice surprise?
So let's take them in reverse, just because that's kind of how I've looked at them. Ms. Taylor, what's the argument again for the court to allow in the CDRs for Harry Lockhart, also known as Plea?
You're right. He was referenced in, well, his name was brought up as having communication with one of the co-conspirators in
Which one?
Justin Johnson.
His name was brought up in text messages or?
No,
in
his
testimony?
name was brought up in Browning's testimony on yesterday.
Okay, as what? I mean,
As having, this was on July 27th. It was in reference to Justin texting him about talking to Juke, and it's also, I believe, relevant as to the text messages that defense has brought in referencing his name. They indicated that Joshua Taylor, Harry Lockhart, I'm sorry, all the names are starting to get confusing. Harry Lockhart was talking, or was referenced in some of Justin's text messages in regards to maybe Justin doing the outside thing, outside of the conspiracy.
and you said specifically on July 27th,
Yes, Your Honor.
as we were going through text messages on yesterday?
No, he was brought up in Browning's testimony
Right.
in regards to July 27th.
So what I'm saying is that did we not see text messages yesterday from July 27th?
Just from Justin Johnson.
Well, that's what we're talking about, right? We're talking about, so we're talking about Justin Johnson's communications with Harry Lockhart.
On yesterday is how Harry Lockhart became relevant. And it's also referenced in Justin Johnson's text message to, I think, another individual
About Harry Lockhart.
about Harry Lockhart.
Okay, so my question to you is that when Sergeant Browning was testifying yesterday going through his PowerPoint, was Harry Lockhart mentioned on the 27th? Since you
Yes.
because you referenced the 27th.
Yes.
That's what I'm saying.
Yes.
And you think it's relevant now, because I'm sure that's what your argument is going to be. I didn't necessarily get that from you. Is your argument that it's not relevant?
Yes, Your Honor, just like yesterday, it's just a passing reference in the text. There's no communication that we introduced to
Right.
him, and you suppressed that yesterday because that's the
Well,
whole point.
I got that, and I agree with what I just read, that it is just passing here. Ms. Taylor just brought up another argument, but that it was brought up in Sergeant Browning's testimony yesterday that there were conversations on text message from Justin Johnson to Harry Lockhart that she says is relevant because Harry Lockhart's name came up yesterday.
Right, it was on direct. They brought it up. It just happens to be a passing thing on cross that we're doing a text message. You can white it out for all I care. I didn't need his name in there. I'm just giving you the text message because Justin Johnson's talking to somebody else and he says, oh, Ham's there too. That's essentially all that is to it. It wasn't relevant and direct when they talked about it yesterday. We didn't bring it up. We didn't emphasize it. We didn't do anything. I don't even know what Ham has to do with the price of tea in China.
But it's now in the text messages that you've entered.
His name,
That's
they
to say
entered.
that you highlighted some text messages, okay?
Right.
That says that you're making the argument that Justin Johnson was having individual conversations outside of Govan, Mr. Govan, about other issues, about
I'm not,
whatever they were talking about.
I'm not highlighting it.
No,
On
you're
direct,
highlighting,
well, it's in there, but
Yeah.
on direct, they brought it up, that Justin got
and I
the checks.
understand, but you've now highlighted it, and so, Ms. Taylor, what's your response that it's not relevant here,
Well-
that it can be whited out as far as he's concerned?
Well, now they want it whited out. They didn't do that yesterday, and they could have done that then. But also, Your Honor, I would further state that there are communications between Mr. Govan and Mr. Lockhart during the time of this conspiracy, which I think is relevant. And if they're gonna bring it up that Justin, may have been doing some outside things, it's important for the jury to also know that Mr. Lockhart had communications with Mr. Govan.
Judge, they brought up the communication between Justin Johnson and him. They brought it up in their text message. It was already there. So when I'm crossing in with some of these other text messages, that guy's name is referenced. We didn't bring any other specific text messages between him and Justin Johnson. They brought it up. It wasn't relevant to them yesterday when they went through a very lengthy direct examination. It's one of their slides out there that says Justin Johnson talked to him. They brought it up. I didn't even ask the name him. I just read the text message like you instructed me to do, and we admitted this stuff. It has nothing to do with anything as far as that goes. They brought it up. And I'm just responding to that. It wasn't relevant in direct examination, but now it's relevant.
What's your
I mean,
response?
I reiterated that, the call records aren't coming in through another witness. These are self-authenticating documents that I feel are relevant to this trial, specifically to Mr. Govan. If their argument is gonna be, which they asserted several times yesterday, that Justin Johnson was going outside this and he was talking about Ham and referencing Ham and sending information about Juke to Ham, it's also relevant that Ham, or Mr. Lockhart, has communications with Govan. It's not outside of the scope of this, of the conspiracy.
Your Honor, they're conflating the issues. They brought up the fact that Justin Johnson was talking to Ham on direct examination outside the scope of the conspiracy. My text messages don't have any communication with Ham. It's through somebody else. If they want to bring in the TZ stuff, I agree. I put in a text between Justin Johnson and TZ. Got it. It's the same argument we went through yesterday on chat. They brought up the text. Now she's making it seem like we somehow manufactured something out there. They brought up the text, indirect, that Ham communicated with Justin Johnson.
And I was under the impression that Ham was mentioned, and I'm looking at Exhibit 26, that Ham was mentioned in this text message from Justin Johnson to TZ, Joshua Taylor. I'm going to exclude that one. As to Harry Lockhart, also known as Ham. You cannot use those.
We have no objection to the TZ one, Your Honor, based on the argument.
All right. So you can use the TZ, Joshua Taylor CDR instead.
Thank you, Your Honor.
Anything else?
Not for Mr. Govan, Your Honor.
Say that again.
Nothing for Mr. Govan.
I'm sorry.
Is your medical examiner here?
Yes, Your Honor.
I want to put her on.
Well, I will just say I have no further questions for Sergeant Brown.
Okay,
I don't know if he's here.
yeah, he can be released, and then bring in the medical examiner. And we'll just let the jury know that he's been released.
And the CDRs with the self-authenticating document will be out there.
Oh, we'll put that, let's get the medical examiner out here, and then we'll put that in.
To finish the list of trash. Sure.
Yes. And you don't have that motion to do that.
Okay, well, I didn't, sometimes I've got on here,
She probably got credit in over there too.
I've got a lot of ladies.
Yeah, there's probably a lot of stuff.
Stand right here, ma'am. Face you on, raise your right hand, please.
Do you swear or affirm to tell the truth?
I do.
Have a seat. Thank you for your presence this morning.
Good morning.
Good morning.
Could you state and spell your name for the record?
My name is Dr. Juliette Scantlebury, Juliette, Scantlebury, Scantlebury,
And where are you employed?
at University of Tennessee, at a West Tennessee Regional Forensic Center.
And what's your position?
I'm an assistant medical examiner,
How long have you been in that position?
6 years.
And what does your job consist of?
My job consists of performing medical legal autopsies to determine cause and manner of death in certain cases in this jurisdiction.
So I want to talk a little bit about your background. Could you tell the jury about your education?
Yes. So I completed a Bachelor of Science in Biology at Howard University. Then I completed my medical degree at Howard University College of Medicine. My anatomic and clinical pathology residency was at Washington University in St. Louis. And then my last training was in forensic pathology fellowship at St. Louis University.
And are you board certified?
I am.
And are you a licensed physician in Tennessee?
I am.
And could you tell the jury what is forensic pathology?
So forensic pathology is a specialized branch of medicine that examines deceased persons to determine the cause and manner of death in a medical legal approach.
So what does a forensic pathologist do?
So a forensic pathologist performs autopsies based on the jurisdiction that they're working in to determine the cause and manner of death for certain types of cases that are under our purview.
And what exactly is an autopsy?
So an autopsy is an extensive examination of a deceased person, have an external examination and an internal examination of the body. So you look at everything from hair color, eye color, their body habitus, see if they have any scars, tattoos. That's external examination. And then the internal examination, depending on the level of autopsy, we'll look at all body cavities, we'll weigh all organs, we'll see if there's any fluid or any evidence of disease in any organs. And we also open the head and look at the brain and take certain fluids to be able to test to determine by toxicology or histology to determine, and with all that together, we determine what most likely caused the death for a person if we do an autopsy.
So Dr. Scantlebury, are there different stages of an autopsy?
Yes.
And what are those stages?
Okay. Autopsy itself is looking at the body, but starts from the investigation. So an investigator will give us some information, and the information we get from the investigator determine what type of autopsy we need to do. And if there's determined that a full autopsy needs to be performed, we might need x-rays, we do that first. Someone will help take all the clothing off, if there are any, take necessary pictures, necessary measurements of the body, the height, weight, and any other identifying characteristics on the body. And then move on to the internal part, and that's where we'll make an incision to open up the body cavity to see the internal cavity and see all the organs and any changes that might have happened that might be related to death or otherwise.
And have you performed an autopsy before?
I have.
About how many would you say?
Over 2,000. I stopped counting after that.
So could you explain to the jury, what does cause of death mean?
So cause of death is the immediate reason that led to a person's death. So it may have different ways of saying. So if it's natural, it would be what medical disease led to the person's death, or if there's any kind of injury that caused the person to no longer be alive.
And is that different from manner of death?
Yes.
How is it different?
So manner of death is the classification of that type of death it was. So it will be how you would want to classify the death. So there are 5 manners of death in this jurisdiction. It may vary in places, but here is natural, accident, suicide, homicide, and undetermined.
And have you ever testified about your findings from an autopsy you did?
Yes.
And have you ever been qualified as an expert witness in the area of forensic pathology?
I have.
And have you been qualified in the courts of this county and other counties?
I have.
Where have you been qualified before?
Illinois, Missouri, and Tennessee.
Your Honor, I tendered Dr. Scantleberry as an expert in forensic pathology and asked that she be allowed to state her opinions as to a reasonable degree of certainty, medical certainty.
No objection.
The court will find that Dr. Scantleberry is an expert in the area of forensic pathology, therefore she can testify as to the cause and manner of death and give her opinions as well.
Thank you. Dr. Scantleberry, I want to ask you about a specific autopsy. Did you perform an autopsy for an Adolph Thornton Jr.?
I did.
Okay. And do you recall when this autopsy was performed?
Yes.
When was it performed?
November 18th, 2021.
Okay. And during the course of conducting this autopsy, did you also take pictures of Mr. Thornton's body?
Pictures were taken.
Okay.
No objections, David.
Okay. I'm passing you a few of the pictures from this autopsy. Dr. Scantleberry, do you recognize the photographs we just handed you?
I do.
Okay. And do they accurately depict the victim and the evidence during the autopsy?
They do.
Okay. Your Honor, I would like to have these photos of the autopsy entered into evidence and marked as the next number exhibit.
Well, she needs to testify about what they are.
If we could enter them as a collective exhibit?
Well, that's fine, but she still, for the record, we need to know what they are. She needs to testify to each of them individually.
Okay.
I mean, you don't have to publish them, that makes me no difference, but she needs to tell us what each one of them is.
Dr. Scantleberry, if you would look at that first picture, what is shown in that first picture?
So this first picture shows the Mr. Thornton on the right side of his body, but some of his head and his right shoulder, and it shows some gunshot wounds of his right jaw, right neck, and right shoulder.
And what about the second picture?
This is a shot of his right upper extremity of gunshot wounds of the right forearm, so here and here.
And what about the third picture?
This is another shot of the right side of his body, mostly with the right arm, and it shows his right hand, and there's a gunshot wound of his right wrist, and it shows another gunshot wound of his right forearm.
And as to the fourth picture?
This shows some other gunshot wounds of his left upper extremity.
And the fifth picture?
So this picture shows the back of Mr. Thornton's body, and you can see both arms and his back, and you can see the majority of the gunshot wounds of the back, and you can also see some gunshot wounds of his upper extremities.
And the sixth picture?
This is another picture showing the same thing, but it was taken from the left side of the body, showing gunshot wounds of the back and upper extremities.
Okay. And the seventh picture?
This is a closer view of the gunshot wounds of the back from the left side of the body.
And the 8th picture?
This is an overall view of the bullet fragments that were recovered from the right jaw from Mr. Thornton.
And the 9th picture?
These are bullet fragments from the torso from Mr. Thornton, pictures of bullet fragments.
And the 10th photo?
This is a remote, shows a picture of the remote bullet from the left thigh.
And the 11th?
This is a remote bullet from the right lobe of the liver.
And the 12th?
This is a bullet core fragment from the right chest.
The 13th?
This is a bullet from the lower mid-back.
The 14th?
And this is a remote bullet from the right buttock.
Your Honor, we'd like to have these photos of the autopsy entered as a collective exhibit.
No objection to any of that.
We're gonna make this a collective exhibit. Pages.
What up, family? Welcome to Flesh
The
and
first 7
Godz.
pages are multiple pictures of Mr. Thornton's body with multiple gunshot wounds. The next 7 are pictures of the fragments that were removed from different parts of his body. We'll mark this as collective exhibit 31.
Thank you. And we have permission to publish?
Yes.
Dr. Scandalberry, we're going to start with the first photo that you viewed. Could you tell us what is seen in this photo?
So in this photo, you see the right side of Mr. Thornton's body. That rectangular object is the case placard with the case number associated with this case. It can be seen. This will help you attach that photo to that particular case. And it can also use the scale for the wounds or anything you need to measure on the body. So on the right side of the body, you see those defects in his right jaw and right neck. Those are gunshot wounds of his right neck and right jaw. And then there's some gunshot-related injuries of the right shoulder.
Did you have any specific findings as to this injuries?
Yes.
What were those findings?
So the injuries of the right jaw and the right neck cause injury to the tongue and skeletal muscle and the right mandible, which is the lower part of your jaw. Those were injured.
Okay. Moving on to the second photo that you viewed. What is shown in this photo?
This is the photo of his right arm. So to the right of the image, that is his right arm. And most of what you can see is right forearm. And this is the front side of it, the anterior portion. You can see those 2 large defects are gunshot wounds.
Okay. Were there exit wounds on this part of his body?
Not that one. Those are kind of graze or tangential wounds.
Got it. Moving on to the third picture. And what is shown?
Oh, sorry.
I'm sorry. What is shown in this picture?
This is a photo of the right side of the body, and you can see a gunshot wound in the right wrist.
Okay.
And another defect a little earlier, a smaller defect.
Moving on to the fourth picture. Could you tell the jury what we see in this photo?
So this is a photo of Mr. Thornton's left forearm, and it shows a gunshot wound and some gunshot-related injuries of the left forearm.
Moving on to the fifth photo. What do we see in this photo?
So this is the backward view of Mr. Thornton. His head is to the right and his feet are to the left of the photo. And you can see his arms, you can see some of the same gunshot wounds you saw in previous photos, but on the back view, you can see the overall view of the gunshot wounds of the back.
Okay. And moving on to the sixth photo.
This is similar, but from the left approach of the body, you can see its overall view of the gunshot wounds of the left, of the back.
Okay. And the seventh photo that you viewed?
This is a closer view of the gunshot wounds of the back from the left side of the body.
Okay. So in total, how many gunshot entrance wounds were there on Mr. Thornton?
Definitive gunshot entrance wounds, 20.
And were there any exit wounds?
Definitive exits, 4.
Okay. And moving on to the eighth photo. What do we see in this photo?
So these are bullet fragments of the right jaw. These are all the larger fragments that were able to be recovered from those wounds that you saw in the right neck and jaw.
And that was from the first photo that we viewed?
Yes.
Okay. And the ninth photo?
These are fragments recovered from the torso.
Okay. And the 10th?
This is a remote bullet from the left thigh.
All right. And the 11th photo?
This is a remote bullet from the right lobe of the liver.
Okay. And the 12th photo?
This is a bullet core fragment recovered from the right chest.
And the 13th photo?
This is a bullet from the lower mid-back.
Okay. And the 14th photo, what do we see here?
This is the underside of a bullet base that was remote, that was recovered from the right buttock.
Can you describe to the jury, what is a remote bullet?
So remote is people use different words. Words can say remote or old, but I choose to use remote. Remote means it's a bullet that is related to a previous injury or previous shooting, not the shooting that led to their death in this case. It's happened before.
Okay. And how many, or do you recall how many remote bullets you might have found?
There were 3.
Okay. So, Dr. Scantlebury, within a reasonable degree of medical certainty, did you render an opinion as to Mr. Thornton's cause of death?
I did.
And what was that opinion?
Gunshot wounds of the head, neck, and torso.
And did you render an opinion as to the manner of death?
I did.
And what was that opinion?
Homicide.
Your Honor, I will pass the witness.
No question, Your Honor. Thank you, Dr. Scantlebury.
Thank you, Dr. Call your next witness.
Your Honor, that is the state's proof, with the exception of the,
Go ahead and read that.
Is it something that you wanted us to read into evidence? This was just a stipulation.
Oh, that wasn't a stipulation.
No, it was.
Your Honor, I'll stipulate to the phone records, no problem.
Did we already put it in the evidence?
No,
We
no.
talked about it. We have put it in the evidence. So ladies and gentlemen, when you go back to deliberate, you will have everything that's been entered as an exhibit. There are at least 2 documents or 2 exhibits that you haven't necessarily heard specific proof about. They are called, what you might have heard is CDRs, called detail records. The law will allow certain records to be entered into evidence without testimony about them. And so that's what Ms. Taylor is getting ready to enter into evidence now. It's been refined by the state, and there was one that was entered yesterday also. So you'll have a few things that you can review, but you haven't necessarily heard testimony about.
Attached is the self-authenticating document and the flash.
This is self-authenticating document for phone number 901-283-3878. From T-Mobile, attested to by a Joe Rico. Also I have here is a zip drive, a blue zip drive that has Joshua Taylor's name on the outside of the envelope, and it has CDR. So these are the call detail records for one Joshua Taylor. Let's enter this as collective exhibit 32. So Ms. Taylor, do you officially want to rest or?
In front of that is the state's proof.
Thank you. Ladies and gentlemen, we need to take a brief break. We're coming back in just a few minutes. You haven't heard all the proof. Continue to do what I know you've been doing, which is not talking about this case. Give us a few minutes. We've got a few legal things to take care of, and we'll call you back in just a few minutes.
Mr. Cornelius has given some, was moving for a directed.
Mr. Roy, you have a motion?
Yes, Your Honor, was moving for a directed verdict, understanding that Mr. Cornelius has given some statements about it, that he was ordered to do it. I don't know if that rises to the level of a conspiracy or agreement amongst the parties. It was very inconsistent as far as that goes. Secondly, there's been no mention of how Justin Johnson is part of the conspiracy at all whatsoever. I understand it only takes two to tango, but I just don't see where the proof adds up to the conspiracy, and certainly not to the first-degree murder charge in count 2, based on the evidence that you've got.
Your Honor, the court is to view the evidence in the light most favorable to the state. We've heard testimony from Ms. Thornton that Mr. Thornton, the victim, was alive, is no longer alive. We heard testimony from Dr. Juliet Skittleberry, who testified as to the cause and the manner of death, which is homicide. We also heard from a few other witnesses, like Cornelia Smith and Angela Arnold, stating that Hernandez Govan is the one that told Smith about this hit on Mr. Thornton and told him about the price. So all that to say, Your Honor, and also, Your Honor, that Justin Johnson was involved and was a part of it. So all that to say, the state would argue that there is enough for a reasonable jury to conclude guilt.
And Your Honor, I have no quibble. Of course, he was alive and he's since passed. I'm just, you heard proof that they didn't communicate for 2 weeks, at least with Justin Johnson, at least 2+ days on the phone calls that the government submitted yesterday. Cornelia Smith, supposed last phone call was on the 15th of November, 2 days prior to the murder. It was for 0 seconds, and then there was that code 11 that Garner talked about, might have been voicemail, that was 40 seconds. We know for a fact that he didn't talk to Justin Johnson based on the phone records for at least 2 weeks prior to the shooting. You're being asked to make a lot of supposition here based on what Cornelia Smith said. Cornelia Smith also said there was no plan. He got a call that morning, they got there, and they were just riding around doing whatever. Now the fact that somebody 3 to 4 months prior to that fact said to you there may be a price on somebody's head, and was it Justin Johnson? I'm sorry, was it Govan or was it Joe? You've heard both things from the same witnesses have said it both ways in uncontroverted evidence. And so I'm not sure, how do you have a plan when I say, hey, there's a hit on these people. Some point in the future they kill them, now I'm on the hook for it. I just don't see how that makes a conspiracy. Generally, there's been meeting in minds as to how, who, what, when, where. Nothing happened. It was just generic. If you believe Cornelius, 4 months prior to the shooting, there's a generic statement that, hey, there's a hit on these guys and you can get paid.
Anything else?
No, Your Honor.
In the light most favorable to the state, the court has heard from different witnesses. There has been some conflicting testimony. However, the court thinks that the state has made a prima facie case for both conspiracy to commit first-degree murder and first-degree murder, and it's a jury question. So I'm going to deny your motion.
Denied.
Ready to present proof?
Could I just throw a couple minutes to see who's here? I told him 10:30. He said, no, if the
Let's stay in a brief recess.
Court stands in a brief recess.
So apparently they've been on break hella long, huh? Oh, they do have one more witness in between right here that came up. Let me see. What up, though, family? Appreciate all y'all being here. Shout out to Wilma. What up, though? I ain't seen you a while in a minute. Good to see you. Dirty work all the way around. That's a fact. That's a fact. Indigo Kepra. What up, though? I see you. Brown Sugar Babe. I see you. Appreciate you joining. Ali. What up, though? What up? What up? What up? Tia C. I see you. Appreciate you, family. Much love, much love. Watch the rise. What up, though? So, yeah, let's keep it rolling. Guess it was kind of good I was late today. Shoot, they've been on break since, this is about 20 minutes. And then they've been on break ever since. Oh, no, it's one little, oh, all right.
Lieutenant Coburn, the same job.
Stand right here, sir. Raise your right hand facing the other.
Do you swear or affirm to tell the truth?
Yes, ma'am.
See, watch this, please.
All right. Could you please tell us your full name, spell out your first and last name, please?
Michael Coburn, Michael Coburn.
And I see the lieutenant bars in your uniform. Could you tell this jury where you work?
I'm currently assigned as a supervisor to crime scene
And with what department?
with the Memphis Police Department.
And how long have you been a police officer?
Almost 28 years,
And how long have you been doing crime scene analysis, I guess?
about 15 years.
Have you been qualified as an expert in crime scene analysis in the past by the state?
I have,
And you testified as an expert?
yes,
Have you testified in Shelby County as an expert?
yes,
And crime scene analysis meaning you look for blood, evidence in cars, houses, stuff like that?
yes,
And that's what you've been qualified on behalf by the state in many cases in the past?
yes.
Your Honor, I move to have Lieutenant Coburn admitted as an expert in crime scene investigation.
How do you, Ms. Williams, any objection?
No, Your Honor.
All right, qualified Lieutenant Michael Coburn as an expert in crime scene analysis.
Yes, sir. Yes, Your Honor. Back in 2021, I think you were a sergeant based on your reports, is that correct?
I was assigned to homicide.
And were you doing crime scene with homicide back in 2021?
I was,
Did you happen to work on the crime scene analysis for the murder case of Adolph Thornton?
for vehicles, yes.
Okay. And did you specifically process a Mercedes-Benz vehicle in that case?
I did,
And was that car recovered, and I guess you looked at it on November 20th of 2021, is that correct?
yes.
Okay. I'm going to show you a few photos that have previously been marked into evidence and just make sure that's the same car, okay?
Okay.
My other lawyer, Robert, will do that. We're going to put in Exhibit 11 that's previously been marked and entered. I know it's a little bit of a distance shot. Does that look like a Mercedes that you processed?
Yes.
Next, please. Exhibit 12, it'll be 12, 13, and 14. I just want to get the jury acclimated to the car. Close-up view of the car.
Yes, sir.
Same license plate and everything that you processed?
It is.
Okay.
13.
Yes, I've said we're gonna do 13 and 14. Just the front view of the same car?
Yes, sir.
Okay. Same thing?
Yes.
All right. And then, where do you process the car?
At 475 Clank, it's a warehouse.
Okay. So, I guess it gets towed over to the police warehouse?
Yes, sir.
All right. With regards to processing the car, can you tell the jury what exactly you do?
Primarily, we document evidence, collect evidence. When we process it, we usually process for prints, touch DNA, and just evidence like clothing or something, anything the investigator is looking for.
You also look for blood?
Yes,
You also look for evidence of somebody trying to clean up the crime scene?
sure.
All right. So, with regards to this Mercedes, I think they used to call it luminol, and that's what you hear on TV, but it's Blue Star now, right? That's what you guys use to look for trace evidence?
Never use Blue Star because luminol requires more darkness than Blue Star does.
All right. And Blue Star was used in this case?
It was.
All right. So, without getting into the nuts and bolts, you process this car with Blue Star?
Correct.
And if I were to tell you that a witness has said that he took a towel, put a bunch of bleach on it, and wiped the car down, is there any evidence of that in this case?
No.
And you would see that with the luminol, that there's bleach and things like that, where somebody's trying to clear a crime scene.
Yes, sir.
Okay, because otherwise people could get away with anything.
Correct.
Did not happen with regards to this car.
No, sir.
So if I said, under oath, I got bleach, put it on a towel, wipe that car down, complete lie.
Yes.
Thank you. No more questions.
He never said bleach though. He said I wiped it down with a towel. I mean, I don't know if he said it prior, but on the stand he didn't say bleach. He said I wiped it down with a towel. He didn't say, and he said cleaning products, but he didn't say what exactly it was.
Well, isn't this a nice surprise?
Chad, my black is golden. What's good? What's good? Appreciate you joining. King Edo, what up? What up, though? Free drop. My boy Innocent and getting lied on. All right, appreciate you, family. What up? What up?
The absence of evidence is not the evidence of absence.
What?
And while they getting it together, y'all shout out to Allie. Oh.
Lieutenant.
Of course, they would start talking as soon as I do that. Y'all give a shout out to Allie, dropping the 10 spot. Appreciate you, family. Let me drop a bomb for you. We're going to keep it rolling. Y'all show her some love. Drop some Allie. Drop some coins in the chat. Appreciate you, family. And let's go.
Very sorry.
That's all right.
Lieutenant Coburn, you processed the white Mercedes, is that correct?
Correct.
You found several prints outside of the car, is that correct?
I did.
You didn't find any prints on the front passenger outside of the vehicle, is that correct?
I'd have to look at the summary of it.
Just one second. Let me ask you also, did you process the inside of the vehicle?
I did.
Did you find any prints of value inside of the vehicle?
I couldn't say without looking at the narrative. No, there's a lot of print cards.
What'd you say?
There's a lot of print cards that I looked at.
Oh.
That's what we put the prints on.
No further questions.
No more questions.
Thank you, Lieutenant. Call your next witness.
I'll call Miss Vivian Ferguson, Your Honor.
Oh, here's another.
She may need some help getting up this steps. Deputy.
Swear or
Yes.
have a seat, ma'am. Watch your step.
Good morning, Miss Ferguson. Would you tell the jury your name and could you spell it for me?
My name is Vivian Banks Ferguson.
And could you spell that just because the court reporter needs to get it right?
Which one?
Your first name, middle name, and last name.
Capital V-I-V-I-A-N. B as in boy, A-N-K-S, Banks. Ferguson, capital F-E-R-G-U-S-O-N.
And Miss Ferguson, how old are you?
80.
Okay. We're never supposed to ask that.
Man, she said with the capital though. How many people still say capital F?
Questions.
That's how you know it. It used to mean something back in the days. It don't know more though.
Do you live next to Cornelius Smith Sr.?
I live next to King Smith, his daddy.
Okay. So his daddy's King Smith lives next door to you, right? And you have to say yes or no. I'm sorry. Miss Ferguson.
Yes.
All right. And Cornelius Smith, that's somebody you know, right?
Yes.
Could you tell the jurors how you know Mr. Cornelius Smith?
He's a young man that lived next door, and the only reason I had to came in contact with him, he always would do nice things for me. Like when I go shopping, he always would get my grocery out the car and bring it in the house for me. That was good for me because I was tired. So that's not only that, that's the only time that he come around. If I needed something done, I could ask him, and he would do it. And if he charged me, I would pay him. But he never charged me for anything. To me, he was a nice kid.
So, Miss Ferguson, you and I talked at your house last week, just a few days ago, right? You'll have to say yes or no.
Yes.
All right. And I also asked you if Cornelius Smith said a few years ago that somebody came by your house to give you $500 for him. Would that be true or false?
That would not be true.
All right. So if Mr. Cornelius Smith said under oath that, like, you're like a grandmother to him, right?
If that's what you want to say?
Okay, I'm just repeating what I've heard in court. So if he said that you got $500 for him to hold, never happened.
Never happened.
Not yesterday, not 5 years ago, not 10 years ago.
No, if somebody was going to leave something for Cornelius at my house, they probably stuck it in my mailbox or something like that, but I haven't received any cash or any envelope for him.
So if somebody said you were specifically given $500, would be a lie.
Would be a lie.
All right. And I'm really sorry to call you. I know the last time you came to court was talking about your son's murder, so I 100% apologize. I know you were very upset outside. So thank you for your honesty.
Okay.
No cross, Your Honor.
Thank you, ma'am, for coming. You're free to go.
Okay.
Call your next witness.
I don't have any more witnesses, Judge. We're gonna rest.
Ladies and gentlemen, we have come to that juncture where you have heard all of the proof, but there's still one more piece left that you don't have, and that is the law that you're going to get from me. So give us a few minutes, and we'll get back with you. So please don't discuss this shit, okay? Thank you.
Did you say please don't discuss this shit? It sounded like she said this shit.
So give us a few minutes, and we'll get back with you. So please don't discuss this shit, okay? Thank you.
I think she said this yet, but it sounded like she said don't discuss this shit. What up, though, family? Appreciate y'all joining. Let's see what else they got. They got a little bit more TiVo time. Let's see.
No. Okay. So I am adding those.
Do we need all the lesser included if I just want to go in the indictment, or is that just something?
Well, it's
I can't go all or nothing?
no.
Okay.
Can't do all or nothing. The Court of Appeals might not like that if they have to review it.
Even if I waive it?
Yeah, because the state, we wouldn't do so. I mean, if y'all agree,
Yeah.
if you agreed, I think I might be able to get away with it, but
Okay.
somebody's gonna be unhappy with that. One party or the other is gonna be unhappy, and like, that's too bad for those legends included, so I'm adding solicitation to both the conspiracy and first-degree murder, and I'm adding accessory after fact to both also. On page 5, in the definition of conspiracy to commit first-degree murder, in paragraph 2, the second part to that was actually the definition of first-degree murder. I'm scratching that. That kind of confuses things. So paragraph 2 will read that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder. Okay. I did add the stipulations. I added the experts. I took out defendant testifying. So let's go back to
The absence of evidence is not the evidence of absence.
What?
on page 4, where I list the charges. Of course, I'm gonna
Shout out to
add
Allie, stream sponsor.
accessory after the fact there. And when it comes to count 2,
What up, TSC? I see you. Appreciate you joining, family. Coming back in, I
added
should say.
solicitation to first-degree murder, second-degree murder, aggravated assault. Do I need to plead on the assault? Just out of an abundance of caution, or y'all do it if I don't? It just kind of feels like overkill for me to get that done.
I don't think it.
Okay, so the parties agree, I will leave it off of assault. Assault is the last offense there. Okay? Anything else?
Yes, Your Honor. We skipped my mind about the mere presence instruction.
Who?
Mere presence instruction.
As to the conspiracy,
As to the conspiracy.
it's in a definition somewhere. Where did I read it?
Thank you.
Hold on, let
It's-
me. It's part of a definition. I think it's probably in the conspiracy definition.
Okay, if it's there, that's fine.
Hold on, let
Page
me.
18.
Page 18. Page 18, Judge.
Alright, page 18. In what? Because now I've added a bunch of stuff. And what is it a part of?
So it's under the criminal responsibility for conduct of another section, right above accomplice.
Okay. Yeah, last paragraph of the second to the additional offense is not sufficient to support a conviction. Good enough? All right.
For just a hard no.
Just a hard no. All right.
And then between closings, we'll need a second to switch those.
That's fine.
I'll over.
That's fine, that's fine. Do I need to put a time limit on closing arguments? I normally don't. But I just need everybody to be reasonable.
Yeah, I'm hoping it's not that long.
You've been pretty fairly reasonable throughout. I haven't had to clear my throat or look at you hard, so.
That's what I always keep on back to you.
Right. I think I know of ways to get your attention, and I don't want to have to do that.
I don't want to go long.
And I'm going to give you the opportunity to present your case. I'm not getting ready to step on that. Just when I start hearing the same things over and over again, I get restless, and that's just.
If I'm doing that, then I've really screwed it up.
Right. Okay. Well, good. So let's stand in recess till 1:30.
Go in recess to 1:30.
All right. Thank you.
William Johnson.
John.
We just have to do that for the court reporter. It's a legal thing. Now, Mr. Johnson, you are actually charged in this case. Is that correct?
Yes, sir.
You are charged with taking possession of some of your brother's property after the Dolph killing, and for aiding him to communicate with another man by the name of Cornelius Smith after the Dolph killing. Okay? You have an attorney for that case, is that correct?
Yes, sir.
And he's actually in the courtroom today.
Yes, sir.
You have pled guilty to being an accessory after the fact, several counts of that offense, for taking control over a car your brother was driving afterwards, for taking control over a phone that your brother had afterwards, and for helping him, by using the phone, communicate with Cornelius Smith. Is that right? And you've entered a guilty plea to those offenses, but you have not been sentenced yet. Is that correct?
Yes, sir.
Meaning that a judge has not had a hearing and told you what your sentence is going to be. Is that correct?
Yes, sir.
Have I told you that it's a very good idea for you to tell the truth, and that the truth could help you at whatever sentencing you have one day?
Yes, sir.
Now, this building and this system is new to you, isn't it? Had you ever...
I need to hear you say yes or no.
Yes, ma'am.
She's recording.
Okay.
Thank you.
Had you ever been arrested before this case?
No, sir.
Ever been to 201 Poplar for court cases and stuff like this before this case?
No, sir.
This was the first time?
Yes, sir.
And it's the only time?
Yes, sir.
I want to ask you about your brother, Justin Johnson, okay? Do you see him in the courtroom?
Yes, sir.
Can you point him out and tell me what he's wearing?
Wearing a gray sweater.
Okay, is he seated here behind these two attorneys? Could the record reflect he's identified as brother Justin Johnson?
Record so reflects he's identified the defendant in court today.
Now, how old are you, Jamarcus?
27.
And how old is your brother?
I think he's 25.
25? Okay. Is he your full brother?
We got the same dad, different moms.
Okay. Same dad, different mother, so half brother or whatever. As y'all grew up, did y'all actually grow up together in the same house every day?
No, sir.
You've described sort of how often you would see your brother Justin. I liken it to something like me and my cousins or something. Does that sound about right?
Yes, sir.
So you grew up in a different household than your brother.
Yes, sir.
Is that correct?
Yes, sir.
Okay. But you would see your brother from time to time? Is that,
Yes, sir.
would you see him at family stuff? Or
Younger, yeah.
when you were younger? Okay. Like cousins or something? Okay. I want to take you back to 2021, okay? November of 2021. Now, did you even know who Dolph was?
A rapper, yeah.
A rapper, okay. So you knew Dolph was a rapper,
Yes, sir.
okay? Did you have anything to do with some sort of plan on the front end to kill Dolph?
No, sir.
Is that anything that you would ever be involved in?
No, sir.
Any sort of plan to kill other PRE? Do you know what PRE is?
Yes, sir.
Okay. Any plan to kill the other PRE artists or anything like that?
No, sir.
Okay. In 2021, about how often would you talk or communicate with your brother Justin?
Like every other week.
Like every other week?
Yes, sir.
In 2021, about how many times do you think you saw him that whole year?
Like 2 or 3 times.
Okay. So in all of 2021, you would have seen him 2 or 3 times.
Yes, sir.
Does that sound about right? And you would have talked to him maybe once a week or every 2 weeks. Is that correct?
Yes, sir.
All right. And again, just because a court reporter, like when you nod your head, I know I know it, but we got a court reporter, okay? All right. So it'd be fair to say that y'all were not close.
Yeah. Nah, we were close, but we didn't talk all the time.
Okay.
Yeah, there's stuff going on. I got my stuff.
Okay. Were his friends your friends?
No, sir.
Okay. So did you know the people he hung out with?
No, sir.
Did you know, for instance, Treon Ingram?
No, sir.
That name mean anything at all to you?
No, sir.
Okay. Where were you living in 2021?
I was 21
When this happened?
when the murder happened.
When this time period that we're talking about, when Dolph got murdered, and when we hear later that Justin gives you his time.
Oh, the Arbor apartments.
The Harbor Sport. Now, what area of Memphis?
East Memphis.
All right, so you were living in East Memphis.
Yes, sir.
Okay. And for people that are not from here, there's downtown.
Yes, sir.
Is that correct? There's Midtown that is next to downtown that includes Crosstown.
Yes, sir.
Okay. There's South Memphis, there's North Memphis,
Yes, sir.
and then there's East Memphis.
Yes, sir.
And you were living out in East Memphis.
Yes, sir.
Who were you living with?
I live with my mom and 2 sisters.
Okay. And
my
did you?
son, yeah.
You have a son, is that correct? And you have custody of your son.
4 custody, yeah.
How old is your son now?
4.
Okay. And were you working back in 2021?
Yes, sir.
Where were you working?
I was working at the Disney warehouse.
Okay, the Disney warehouse. All right. Trying to support your son
Yes, sir.
and living in those apartments with your mom and your sisters.
Yes, sir.
Did there come a time after Dolph was killed that your brother Justin got in contact with you?
Yes, sir.
What was it about?
About bringing me a rental car.
About bringing you a rental car. Now, had you asked him for a car or anything?
No.
Okay, so this is...
Do you know what out of the blue means? Would this be something sort of out of the blue? No, he knew I didn't have a car.
Okay, your brother would have known you didn't have a car.
Yeah, he knew I didn't have a car.
Okay. And was not having a car hard for you?
Yes, sir.
Who had to drive you to the warehouse?
I had to get rides from different people.
You had to get rides. Okay. So your brother, is this after Dolph was killed?
Yes, sir.
Okay. Calls you about giving you a car.
Yes, sir.
Does this sound good to you?
Yes, sir.
All right. What happens after the phone call?
I was getting out from work. On the way home, he was gonna call and bring me the car so I can get back and forth to work. And, you know, I can get the car stuff.
Okay. And did he in fact do that?
Yes, sir.
Where did he,
Like an hour later, returned to the office.
like an hour later? At your apartment complex? Okay. What kind of car did he arrive in?
It was a white Chrysler.
Okay. You know what a Chrysler 200 or 300 looks like?
I think it was a 300.
Okay. Oh, they look similar, 200, 300, right? I was just asking, does it look like one of those things?
Yes, sir.
Okay. Is he driving that car?
Yes, sir.
Does he have anybody with him?
There was some people in the truck.
What kind of truck is it? Okay. What color is the truck?
It was white.
A white truck? You say truck, you mean like a pickup truck, or do you mean like a big SUV?
It was a big SUV.
Big SUV? Okay. Do you know who the people were in the white SUV with him were?
No, sir.
Okay, what happens when he gets there?
Tell me you outside.
Okay.
Go outside, get in the car.
You get in the car with him? Alright.
Quiet. He had 2 bombs.
Okay.
And so I guess he just put the numbers in the phone and stuff.
Here's him what?
They like switched the numbers. Put numbers in the phone, another phone.
Okay, so he has 2 phones in front of you. And it looks like he's taking numbers from one and putting it in the other.
Yeah.
Okay, now had y'all talked about a phone or anything before? Well, he was bringing your car. You're in the car. He's got 2 phones. Before this conversation about bringing you a car and stuff, when was the last time you had talked to him?
Probably like 2 or 3 weeks before.
Okay. Alright, so you meet him in the car, he's got the 2 phones, and he's going back and forth with the numbers. Were you asking what he's doing, or what's going on?
He was just quiet.
Okay. And what are you doing?
I was on my phone.
Okay. So you're sitting there next to him, you're on your phone, he's doing his numbers. What happens?
He told me he was going to give me the phone. Like social media stuff.
Like that he's going to give you one of his 2 phones. Okay. And you said for social media stuff?
Yeah, posting pictures and checking your emails and stuff.
Does your brother have social media?
Yeah, that's true. Yeah.
Okay. In fact, you know your brother, does he go by other names too?
Other than his real name.
Uh-huh.
Straight drop.
Okay. Straight drop and sometimes just drop.
Yeah, that's his real name.
Okay. And when you say give it to you for his social media, what do you mean by that?
Kind of like, I guess it was just busy and they needed me to keep up with like the people that was emailing like these.
Okay, so
Producers, stuff like that.
alright, so let me back up. He gives you his phone. Because is the idea that people may be calling or texting or messaging him?
You can say that, but it was just, mainly he just told me that you need to be like to post some stuff.
Okay, so he told you the time that he needed you to use his phone and maybe post some stuff to his social media. Is that
like videos, all this stuff?
okay? Did you ask him why he couldn't do this himself with his phone? Okay, well, he has this phone in his hand. And he's going to give it to you, and you already have a phone. You don't need a phone. The car sounds good. And he wants you to have his phone and maybe post stuff to social media.
Yes, sir.
Okay. You don't ask him why. Does he provide any explanation?
Other than just for the social media stuff.
Okay. He doesn't say why he needs you to do this rather than him. Does he tell you that he's getting out of town?
No, sir.
Does he tell you that he's got to lay low?
No, sir.
What happens after he gives you the phone?
Somebody was calling him, like rushing to come out.
In the car there? So he's getting a phone call from while he's in there?
Yeah.
On one phone or the other, do you remember? Okay. And so does that end y'all's little meeting?
Nah.
Okay. What
He was
happens?
still sitting now.
Okay.
And he was still on the side going from,
Still putting numbers back and forth?
I mean, he did, but I wasn't looking to see what he was doing, but that's what it looked like he was doing.
Okay.
He was looking at both phones.
Once got done putting numbers or whatever he was doing with both phones at the same time, what happened?
Nah, I asked him, was he straight? He said, yeah. Then they called again. Whoever it was, called him again. Anybody to come speak out of the car, then he did. I went in the house.
Okay, so he gets out of the car? Did he get in that white SUV with other people?
Yeah.
Okay, and you go into the house. And now you have a car that he's given you. Alright? And you have a telephone that was his.
Yes, sir.
You got to be more specific.
After you get possession of this phone, do people start trying to contact him on this phone?
Yes, sir.
Alright, but you have the phone.
Yes, sir.
What happens when somebody contacts him on the phone that you have?
I text him and tell him that they called or text.
Okay, so if somebody calls him or texts him and you then text him or call him and say so-and-so just texted or called you, is that right?
Yes, sir.
Were there ever times that somebody would call that phone and then you and your phone would call another phone and put them together so that they could talk?
Yes, sir.
Okay, so you could aid in those sort of, sometimes we call three-way or whatever.
Oh, damn, that was that. How could you not know what was going on?
Conversations between him and other people.
Yes, sir.
Among those sort of three-way conversations, did he ever talk to somebody identified as C?
The name in the phone was C Girl.
Okay. And the voice, was it a male or a woman?
The one time that I did hear you sound like
Sound like a dude. Okay. At the time, did you know who C was?
no, sir.
Do you now know that to be Cornelius?
Yes, sir.
Were you able to hear the conversation going on between Justin on one end of the line and Cornelius, since you are sort of three-way there?
Not like full conversation.
Not the full conversation. Were you able to hear some of the conversation?
I'm not really just listening.
Okay. You've been asked before whether or not you heard some of the conversation, correct? And have you described part of the conversation having to do with money?
Yes, sir.
Having to do with getting money to C?
The text message.
The text messages?
Yeah.
And what was it about?
It was like, he just kept saying like, what's up, bro? What's up, bro?
Stuff like that. And I was texting my brother, and I was telling him somebody texting you, and he was like, who he is and what he want. And then when I told him, he kept saying like he loved him and stuff like that. And then he said, have you talked to Unc?
Okay. Did you know who Unc was at that time?
No, sir. He said, talk to him. Then he said, if you talk to him, tell him I need some money for my little girl's birthday party.
Okay.
Yeah.
And did that make any sense to you?
I really don't care.
About money, though.
Mm-hmm.
The money that would be coming from Justin and Unc to this C person.
I don't think it was coming from Justin. I think it was just coming from Unc.
Coming from Unc.
He was telling him to ask Unc.
Okay. So C was asking Justin to ask Unc where the money is. At the time, did you know who Unc was? At the time, had you ever even heard of Big Joke?
I knew he was, yeah.
Had you ever met him?
No.
You ever talked to him?
No, sir.
Okay, but you knew his name?
Yeah.
From the rap game and everything else?
Mm-hmm.
Did you use that phone like that? I mean, would various people text and call, and then you tell your brother, hey, so-and-so text and call?
It was only it was a couple people. Yeah.
A couple people? Okay. During the course of doing this, did your brother ever tell you where he was?
Talking about after he left from
He never told you where he was?
No, sir.
Okay. At some point, the police come to you, is that right?
Yes, sir.
They come to your apartment?
Yes, sir.
And they want something you got. Is that right?
Yes, sir.
They want that phone.
Yes, sir.
Your brother's phone.
Yes, sir.
And did you give him that phone?
Yes, sir.
And did you agree with to go back to the station with them and, be interviewed by the police? Did you do that?
They took me there.
They took you there, okay.
Yeah.
They took you there. You turned over the phone and told them about Justin giving it to you.
Yes, sir.
Now, the original reason that he gave you for this phone was so you could do postings on social media and stuff.
Yes, sir.
Did you do postings on social media for him while he was gone?
Yes, sir. It was like 2 pictures.
Which 2 pictures?
It was like a picture of some food, like a restaurant.
Okay.
And another one was like some shoes.
Okay. So you posted 2 pictures for him. Which would be a picture of some fancy shoes?
Just some Jordans.
Some Jordans. And a picture of some food. And did he ask you to post those pictures?
Yes, sir.
Okay. Did you also follow his social media? Could you see the stuff he posted on social media?
Yes, sir.
Was he still posting stuff on his social media? But not just you? Like a picture of him in a Rolls Royce, or a picture of him holding tens and tens of thousands of dollars?
Not like around the time I posted those pictures.
I understand.
Straight on down the line, yeah.
Further on down the line? Okay. Before he got arrested?
Yes, sir.
So that's not you posting those pictures?
No, sir.
In fact, I think they had probably already had, the police already had the phone at that point.
Yes, sir.
Pass you exhibit 57 and 56. Tell me who's in this picture, if you would. I think you've seen those before, Jamarcus, is that right?
Yeah.
Who's in those pictures?
Justin.
Your brother, Justin?
Uh-huh.
I could have those exhibits returned. I'm done asking you questions, Jamarcus.
One moment, Your Honor. Good afternoon, Jamarcus. If you don't mind, I'll call you Jamarcus since we have more than one Mr. Johnson in the request. All right. My name's Luke Evans. I just got maybe just one question for you, or a couple of questions for you. So you knew Justin to be an aspiring rapper.
Yes, sir.
Correct. He was trying to get signed.
Yes, sir.
Okay. Had you ever, prior to that date, ran his social media or YouTube before?
Yes, sir.
All right, so that wasn't something, that wasn't a new thing for him to ask.
Excuse yourself. Thank you. You ready?
Yes, sir.
Right here.
Perfect timing. We just finished up and now we back live. Great timing. What up, family? Let's keep it rolling. Hit that like, hit that subscribe, tap in, share with a friend.
Somebody went to the restaurant. I just heard it.
Well, isn't this a nice surprise?
Sometimes you just gotta trust the process. Everything gonna work out like it's supposed to.
Yeah. Tell them to come on in now.
Ready, huh?
Yes.
Jury's now in into the courtroom.
You guys had a big lunch. Y'all stay away. Are there any family or anybody over here, as far as you know, out there off the market?
No,
Okay. Those of you who just joined us in the audience, I am preparing to read the jury charge. It's lengthy. It's going to take me about 15 minutes or so to read it. If you're going to have difficulty sitting still during this time, I ask you to excuse yourself now. You're welcome to come back in once the lawyers start their closing arguments. But there will be no movement during this time while we read the instructions to the jury. The doors will be locked. There won't be any in and out. So this is the next part to this. This is my instructions to you. The law requires that I read this to you. I don't want to insult anybody's intelligence. I believe everybody can read, but the law does require that you hear it and hear it all at the same time. So I must read it all to you. Okay? Tennessee versus Hernandez Govan. Members of the jury, the evidence in the case has been completed, and it is now my duty to instruct you as to the law. After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Ladies and gentlemen, the copy that you have there is for your use, so feel free to mark it up as you please. Duties of the court and jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate. Formal charge, not evidence. The indictment in this case is a formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statement were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on these statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding the case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. And this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element necessary to constitute the offense. Crimes charged and plea. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within this offense is the lesser included offenses of facilitation to wit conspiracy to commit first-degree murder, solicitation to wit conspiracy to commit first-degree murder, accessory after the fact to wit conspiracy to commit first-degree murder. The second count of the indictment charges the offense. The second count of the indictment charges the offense of first-degree murder. Embraced and included within this offense are the lesser included offenses of second-degree murder, facilitation to wit first-degree murder, solicitation to wit first-degree murder, facilitation to wit second-degree murder, solicitation to wit second-degree murder, aggravated assault, facilitation to wit aggravated assault, solicitation to wit aggravated assault, accessory after the fact to wit first-degree murder, assault. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find a defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of the conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific felony of facilitation to wit, conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on pages 4 and 5 for you. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation to wit, conspiracy to commit first-degree murder. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find the defendant guilty of solicitation, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant, by means of oral, written, electronic communication, directly or through another intentionally commanded, requested, hired another to commit the offense of conspiracy to commit first-degree murder with the intent that the offense of conspiracy to commit first-degree murder be committed. Intentionally intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Accessory after the fact, to wit, conspiracy to commit first-degree murder. Any person who commits the offense of accessory after the fact is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew or had reasonable grounds to believe that Justin Johnson and Cornelius Smith committed first-degree murder, a felony, and that the defendant acted with the intent to hinder the arrest, trial, conviction, or punishment of Justin Johnson and Cornelius Smith, and that the defendant provided or aided in providing Justin Johnson and Cornelius Smith with any means of avoiding arrest, trial, conviction, or punishment. Knowing means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 2 in the indictment. First-degree murder. A person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intention to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Facilitation to wit, first-degree murder. Any person who commits the offense of facilitation to wit, first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific felony of first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or the results of the offense, and that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder is previously defined on page 10. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, second-degree murder. Any person who commits the offense of facilitation to wit, second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific felony of second-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder is previously defined on page 11. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation to wit first-degree murder. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation to wit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of first-degree murder with the intent that the offense of first-degree murder be committed. Intentionally intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Solicitation to wit second-degree murder. A person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation to wit second-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of second-degree murder with the intent that the offense of second-degree murder be committed. Intentionally intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit aggravated assault. Any person who commits the offense of facilitation to wit aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. Aggravated assault has been previously defined on page 15. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation to wit, aggravated assault. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation to wit, aggravated assault, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of aggravated assault with the intent that the offense of aggravated assault be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Accessory after the fact to wit, first-degree murder. Any person who commits the offense of accessory after the fact is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew or had reasonable grounds to believe that Justin Johnson and Cornelius Smith committed first-degree murder, a felony, that the defendant acted with the intent to hinder the arrest, trial, conviction, or punishment of Justin Johnson and Cornelius Smith, and that the defendant provided or aided in providing Justin Johnson and Cornelius Smith with any means of avoiding arrest, trial, conviction, or punishment. Knowing means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted intentionally, knowingly, or recklessly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. The defendant has pleaded not guilty to each and every offense charged and included in the indictment.
Judge double cup doubled up.
Direct and circumstantial evidence. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which gives you clues about what happens in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. The defendant may be convicted on direct evidence, circumstantial evidence, or both. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. To find the defendant criminally responsible for the act of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for the said offense committed by the conduct of another, you must find that all the essential elements of said offense have been proven by the state beyond a reasonable doubt. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all of the evidence presented in this case by the state and by the defendant and give it a full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them, if you can. For the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. whether the witness had a motive to testify truthfully or to testify untruthfully, and any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all of the evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Expert witness. During the trial, you heard the expert testimony of Dr. Juliet Scantleberry, who was described as an expert in the field of forensic pathology. You also heard the expert testimony of Lieutenant Michael Coburn, who was described as an expert in the field of crime scene analysis. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. In giving her opinion, Dr. Scantleberry testified that she took into consideration certain statements made by other persons. Because the statements were made outside the courtroom, they may be used by you only for evaluating the expert witness's opinion testimony and cannot be relied upon as proof of the truth of the matter asserted in those statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept that opinion. The same as with any other witness. It is up to you to decide whether you believe the testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulations. A stipulation is an agreement between the parties. The parties have stipulated in 3 situations that certain matters of fact are true. They are bound by these agreements, and in your considerations of the evidence, you are to treat these facts as proved. The parties have entered into 3 different stipulations. The first stipulation was entered as Exhibit 17. The parties have agreed that the phone number 901-859-1460 belonged to Hernandez Govan. The second stipulation was entered as Exhibit number 24. The parties have agreed that phone number 901-618-3848 belongs to Hernandez Govan. The third stipulation was entered as collective exhibit number 33. The parties have agreed to enter into evidence certain sound bites played and testified to by witnesses Angela Arnold, Cornelius Smith, and Detective Jesse Brown. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view of reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effects of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. These are my instructions to you. We are now ready for closing arguments.
¿Qué puñetas? ¿Qué puñetas? ¿Qué puñetas?
About to start closing arguments, family. Man, she was struggling. She was I don't know. She needs to drink some water. I'll say that. She was she definitely having a couple issues getting through that. I thought she was crying too. I looked up. I was like, what the hell?
¿Qué puñetas? ¿Qué puñetas? ¿Qué puñetas?
Good afternoon.
Good afternoon.
So earlier this week, you heard me talk about choices. And I warned you, you would hear a lot of evidence, you would hear a lot of voices, you would see a lot of footage, hear a lot of names. But I also told you, if you'll remember, that the name that you needed to focus on and the name that you needed to remember is Hernandez Govan. But most importantly, I told you you needed to focus on the consequences of his choices. Hernandez Govan and the consequences of his choices. And the consequences. What were those consequences? Violence, death, and loss. And not just the violent death of a famous music artist, but the violent death of a human being, a person, someone whose life was marked with artistry, community, entrepreneurship. So let's take one last look at how that life ended.
evidence is not the evidence of absence.
What?
What they looking at? I don't even know what they looking at. I'm gonna have to rewind on my phone and see what she said they was looking at. I thought they was about to show something, so I wasn't really tripping, but let me see what she said. I'm gonna rewind it on my
a life, ladies and gentlemen. But before I get into how much we've heard this week and what exactly we've heard this week, let's talk about the law. And let's talk about what the judge instructed you. Conspiracy to commit first-degree murder. That's the first count. In order for there to be a conspiracy to commit first-degree murder, there has to be four things. There has to be an agreement with one or more people to commit the offense of first-degree murder. There has to be, or number two, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acting for the purpose of promoting or facilitating the commission of the offense of the first-degree murder agreed that one or more of them would engage in the conduct which constitutes the first-degree murder. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. The two important things about this charge is an agreement and an overt act. And in the jury instructions, you heard that an overt act is done by one or more of the parties in order to carry out the intent of the conspiracy. And it must be a step toward the execution of the conspiracy. In first-degree murder cases, often enough, the overt act is the murder. Count number 2. First-degree murder. A definition of first-degree murder is the premeditated killing of another. Number 1, someone unlawfully killed the victim. 2, they acted intentionally. And 3, the killing was premeditated. You heard in the jury instruction that in order for there to be intent, there has to be a conscious objective or a desire. You also heard about criminal responsibility. Criminal responsibility, that basically means that you don't have to be the person that pulls the trigger in order to be responsible for the first-degree murder. The jury instructions say that criminal responsibility is when someone acts with the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense. The defendant acts, solicits, directs, aids, or attempts to aid another person to commit the offense. Further, they don't have to be present when the offense is taking place. Encouragement of the offense is enough. So let's talk about what we heard this week. We heard first from Erica Thornton. She told you that she is the victim's sister. They were close. And the last time that she saw him was on FaceTime. The next thing she hears that her brother was taken from her. She told you about the person that she knew, the brother that she had, and the life that was lost. A life, ladies and gentlemen. We also heard from Raul Hopkins. He told you that he had been employed with Mr. Thornton for years as his security. He explained to you the tension between PRE and CMG. And he explained to you that CMG wanted Thornton to sign with them, but he didn't. And because of that, there's been tension. He talked about diss tracks. He talked about various acts of violence committed on Thornton. And he told you about CMG and their connections. Well, as you've heard from the testimony this week, Hernandez Govan is affiliated with CMG. He has connections within CMG. CMG was in direct conflict with Thornton and the life and the legacy that he built. Govan had an in with CMG. Govan had a direct conflict with the life and the legacy that Thornton built. And then you heard from Cornelius Smith. And that's where it got interesting. He told you that he met Govan in 2021 through a friend named Bobby Carter. The relationship started out as transactional. Cornelius Smith had a pill problem. Govan provided the pills. But then one day, Govan asks him if he wants to make some money. Smith told you that, of course, he has a drug problem. He has 5 kids. He needed money. So, of course, he wants to make money. And he tells you about several discussions between Govan, himself, Justin Johnson, and Jook. He tells you that at one of those meetings, Govan told him that there were multiple bounties on PRE artists, including Mr. Thornton, but also Paper Route Wu. He told you that on one night, he was given guns by Govan. He was given guns by Govan to attempt a hit on Paper Route Wu. He told you that the multiple bounties, out of the multiple bounties on PRE artists, Thornton's was the highest. Thornton's was $100,000. So of course he jumped on the opportunity. And Smith told on himself. He told you everything. He told you chapter and verse, who was in the room and what was said. And if you're thinking about a conspiracy, who would you want to hear from the most? A co-conspirator. Someone that is in the room, someone who can tell you what happened, what was agreed to, what went on. So after he found out about what this bounty was, he talked about November. He talked about how him and Justin knew about a turkey drive that PRE hosts every November. He told you that there were a few days where they went hunting. They knew that there was going to be multiple days where the turkey drives were happening. On the 16th, him and Justin Johnson went out hunting. Wasn't successful. On the 17th, he told you that Justin picked him up from his father's house. He told you that when he picked him up from his father's house, Smith and Johnson went hunting again. And when they were at the intersection of Lamar and Airways, they saw Dolph's car drive past. Earlier this week, I told you that most Memphians know Adolph Thornton's car when they see it. And Cornelius Smith told you the same thing. They knew who it was when he drove past. So they followed the car. They followed the car all the way to Makita's, and at Makita's, they pulled around, parked the white Mercedes that they were in, got out, gunned down Adolph Thornton, and killed him. They got back in the white Mercedes, and they left, but not before Marcus Thornton shot Cornelius Smith. Smith also told you that they ditched the car. He told you that they ditched the car on Bradley Street, across the street from the defendant's home. He told you that once they left the car there, they went to 2-Lane Apartments. At 2-Lane Apartments, that's where they switched clothes, that's where they had their wound kits, and that's where Cornelius realized that he left his phone. He left his phone and he needed a ride. So he used his co-conspirator's phone, Justin Johnson, to contact his girlfriend to pick him up. And you heard that from Angela Arnold too. She told you that she got some communication from a phone number that she did not recognize. A phone number that was not her boyfriend's. It was not Cornelius's. He told her to pick her up, and she did. When she picked him up, he got inside the car. He told her that he had been hit. He told her what happened. And he told her that they killed Dolph. You also heard from Angela that he had previously told her that there was a hit on PRE artists, but she didn't believe him. But he told her. And he told her that there was a bounty. And when she picked him up that day, she learned that they had killed Dolph. They both testified that after they left the 2-lane apartments, they went to a gas station for Cornelius to buy some cigarettes. And after they left that gas station, they met up with Govan. They met up at the Pressure World. And at the Pressure World, Cornelius said that he got his phone back, and he got out the car. Well, first he got out the car. Then he went and talked to Govan, who was already outside the car. And he got his phone back and got back inside of Angela Arnold's car. Angela Arnold also testified that the same thing happened. She's never been to Pressure World before. She's driven past, but on this particular day, she pulled in. Cornelius got outside the car. Govan was waiting for him, and they went to the back and they talked. She didn't hear anything, but she saw the defendant there. And she knew that Cornelius had to get his phone. But then, Angela tells us, and she confirms what Cornelius already told you, that they had to get a car cover. She didn't know who the order came from, but she knew that they had to get she knew that they had to get a car cover. And Cornelius testified that he got the cash from Govan to get a car cover. So that's where they went. They got the car cover. But if you remember, Angela Arnold told us that there was some point where she dropped Cornelius off on Bradley Street for him to wipe down the car. She made a loop, she came back and she picked him up. Cornelius told you the same thing. He told you that he wiped down the car. One piece of information given by 2 different people saying the same thing. And then, if we're going back to what Cornelius told you, he told you that shortly before he was arrested, he ran into Hernandez Govan in the street. They parked their cars, they talked. Govan was worried that Smith didn't get any money. He told Smith, I'm going to go to prison. I'm going to make sure you get your money. Well, of course he wanted to make sure that Cornelius got his money because he had previously asked for a $10,000 cut. He wanted his money too. Angela Arnold told you the same thing. She told you that Cornelius told her about this meeting in the street. She told you that Govan told Cornelius that he was going to go get his money. Cornelius told you that on the day that he was arrested, he was buying cake and ice cream for his daughter on her birthday. He told you how he got arrested. And Angela Arnold told you the same thing. One story, 2 people who told you the same thing. And we also heard from Sergeant Dabney. He was the case officer. He testified that he he and other officers found the white Mercedes in the back of 1174 Bradley, directly across the street from the defendant's home. He told you, or he described the description of the car. He went through slide by slide, picture by picture, and told you that this was the white Mercedes that was used in the homicide to kill Adolph Thornton Jr. And then we got to Sergeant Browning. He went back to August 13th. He told you about an attempted shooting or attempted murder on someone named Paper Route Wu. And remember, Cornelius already told you that Govan told him that there were multiple bounties on PRE artists, including Paper Route Wu, also known as Terrence Baker. On this date, 911 dispatch received multiple calls about shots being fired in the area of 3645 Allendale Road. This is the shooting that Cornelius was talking about. The shooting that happened because of the guns that Govan provided. And on this day, there were multiple calls from Hernandez Govan to Justin Johnson, another one of the conspirators. 12 calls, or 12 communications, between Hernandez Govan and Justin Johnson on the day of the Paper Route Wu shooting. 8 calls, or 8 communications between Hernandez Govan and Cornelius Smith on the date of this Paper Route Wu shooting. 4 calls between Hernandez Govan and Anthony Mims, otherwise known as Big Joke, the number 2 person at CMG, on the day of the Paper Route Wu shooting. And then we get to November. We're going to talk about the conspirator communications. Defense will have you believe that there was no communication between Hernandez Govan and the rest of the conspirators. Sergeant Browning testified that on November 2nd, 2021, there were 7 communications between Justin Johnson and the number for Hernandez Govan. On November 3rd, 7 communications between Justin Johnson and Hernandez Govan. 20 communications between Cornelius Smith and Hernandez Govan. On November 4th, 7 communications between Justin Johnson and Hernandez Govan. 2 communications between Cornelius Smith and Hernandez Govan. On November 5th, 1 communication between Justin Johnson and Hernandez Govan. 4 communications between Cornelius Smith and Hernandez Govan. And as we get closer to the murder, November 6th, 4 communications between Cornelius Smith and Hernandez Govan. November 12th, 5 communications between Cornelius Smith and Hernandez Govan. November 15th, 2 days before the homicide, 2 communications between Cornelius Smith and Hernandez Govan. You heard it from defense that there was hardly any communication between Hernandez Govan and the conspirators immediately prior to the murder. But you see here that there was communication. November 17th, the day of the homicide. On this day, 17 communications between Hernandez Govan and Cornelius Smith, the person he chose to do a job. On November 17th, the day of the homicide, 15 communications between Justin Johnson and Hernandez Govan, the person Govan chose to do this job. And 3 communications from another number of Hernandez Govan, ending in 1460. Another thing about these call records is that it confirmed a lot of what Cornelius Smith told us. Cornelius Smith told us that he left his phone in the car on the day of the homicide. Well, the call records show that there are no outgoing communications from 12:04 hours to 14:36 hours, which would coincide with Cornelius Smith not having access to his phone during that time because he left it in the white Mercedes. These are surveillance footage that we've previously seen. Cornelius Smith told you chapter and verse that it was him and Justin Johnson that did this. He told you they entered into an agreement. He told you that the reason they entered into the agreement was because of the $100,000 bounty. These records show that Cornelius didn't have his phone. He told you that he needed Justin Johnson's phone to contact Angela. And he said that he used Justin Johnson's phone, as indicated by the records. This shows that an outgoing communication from Justin Johnson's phone to Angela Arnold's phone, given the address of the 2-lane apartments. And then he told you that he needed to get his phone back. Well, whose phone did he use? There's an outgoing communication from Angela Arnold's phone saying, "This Zebra, send me bruh number so I can get my phone," to Justin Johnson. And then they asked for Quez's number. And shortly after these text messages were sent, Angela Arnold and Cornelius Smith met Govan at the Pressure World. They told you that they went to AutoZone for a car cover. Well, the phone extractions say the same thing. There was a receipt from around that time from AutoZone, or at least it looked like it was from AutoZone. Further, Cornelius told you that he wanted his money. He needed his money. And that communication with Juk wasn't really a thing. He would use Govan as the go-between person to contact Juk. But he still needed his money. So he found a way to message Juk, and he told Juk, "What's up, big bruh? I'm trying to get with you. I'm Govan's little homie you met before. I've been trying to let you hear my music if you don't mind giving me a call." Govan's homie. Govan's chosen person for the job. Ladies and gentlemen, we went from this person, this life, to this. You heard from Dr. Scantleberry. 20 gunshot entrance wounds to Adolph Thornton's body. We went slide by slide, picture by picture, documenting the injuries that Adolph Thornton received on the day of the homicide. She told you about the manner of death, the cause of death. She went through his injuries, the remote bullets. She told you about the wound on his face. We went from this to this. The defense will try to tell you that the police officers didn't do a good job, that the investigation wasn't complete. But yet, they put on an officer as their witness. It seems as if the investigation isn't good if it doesn't cater to Hernandez Govan. It seems as if the investigation isn't complete when it doesn't benefit the defense. You heard from Sergeant Browning that this was a two-part investigation, and that he came and he started to get involved when Angela Arnold talked to officers about Hernandez Govan's involvement. Her interview was December 17, 2021, a month after the murder. It was a month in before they even realized that Hernandez Govan was involved. You also heard that Justin had access to Judd, and that Justin was communicating with other people and he was doing his own thing. But that doesn't take away from this conspiracy. That doesn't mean that this didn't happen. That doesn't mean that Govan is not involved. Govan already had Judd's contact information. He already had Justin Johnson's contact information. He already had Cornelius Smith's contact information. And if you look at the text messages that the defense entered into evidence, you see that there is communication with people that Hernandez Govan also communicates with, like Joshua Taylor. Defense will also tell you that the investigation wasn't complete because there were other people involved that weren't charged. Well, we heard from Sergeant Browning that this investigation is ongoing. By definition, a conspiracy is an ongoing crime that is continuous in nature. And sometimes you just don't have all you need to charge people. Sometimes people die. You can't indict people that aren't here anymore. And if all that isn't enough, you heard from someone that was in the room when it happened. You heard Cornelius Smith. You saw the videos. You heard the testimony of Angela Arnold and Sergeant Browning that support what he's telling you. Defense introduced a video of Cornelius Smith on December 9th, 2021, the day that he got arrested. He told you himself he was a pillhead. He was high. And you saw that in the video. Even Angela Arnold told you that the day that he got arrested, when she was with him, he had taken some pain medication. And ladies and gentlemen, remember the call records. These communications don't lie. They coincided with dates of importance. The week of the turkey drive, August 13th, the shooting on Paper Route Woo. They don't lie, ladies and gentlemen. So let's get into the law one more time. Conspiracy to commit first-degree murder. The defendant entered into an agreement. What is the agreement? What is the agreement? The agreement is if you kill Dolph, you get $100,000. You need one or more people to be a participant in that agreement. You heard from one of them, Cornelius Smith. We know there's Justin Johnson, and there's Hernandez Govan. There is an agreement. And what also do you need? You need an overt act. Earlier I told you that an overt act in the murder case is often the murder. Well, you saw videos of that. You heard the defendant, you heard the shooter, Cornelius Smith, testify that he killed Adolph Thornton Jr. For first-degree murder, it has to be a premeditated killing of another. When we talk about premeditation, we know that there's no timeline on premeditation. It could be months, it could be weeks, it could be days, it could be a few minutes. All you have to do is have time to reflect. All you have to do is have time to think about what you're doing. Well, they had plenty of time. Cornelius said that they talked about this well before this murder. And we saw that the hit on Paper Route Woo was on August 13th. There was plenty of time to think and reflect about this murder. And as you saw from the video, it happened. For criminal responsibility, all you have to do is you have to have an act with the intent to promote or assist the commission of the offense or to benefit in the proceeds or the results of the offense. Smith told you Govan wanted his cut. He wanted $10,000 from Justin Johnson's cut and from Cornelius Smith's cut. That sounds like proceeds. Further, you don't have to be there when the trigger is pulled. You saw the video, you know that Hernandez Govan wasn't there, but that doesn't mean that he is not responsible for ending this life. Ladies and gentlemen, the state's burden is reasonable doubt. You heard in the jury instructions that reasonable doubt means moral certainty. You have to be certain for every element of the offense. That's my job. Certainty means that you can sleep easy at night knowing the decision that you made. It's not beyond a shadow of a doubt. It's not 100% certainty. It's not beyond all doubt. It's beyond a reasonable doubt. That is the standard. Once you've looked and reviewed all of the evidence, all of the photos, all of the videos and testimony that you've heard this week, it is the state's position that we have fulfilled our burden. We ask that you, the jury, make a choice. We ask that you make a choice to hold the defendant, Hernandez Govan, responsible for his actions. We ask that you find him guilty of first-degree murder and conspiracy to commit first-degree murder. Thank you.
Can we take a break, Your Honor, just so I can get set up? 5 minutes, I just have to switch the software over and have the deputy do my voting.
Let's stand in a brief 5-minute break and grab some break.
Court stands in recess 5 minutes.
What y'all think, family? How'd y'all? Let me see. What's the results of the votes? The results of the votes is 33% say good. He is guilty. She did good. How is the state's closing? Is the question. 0 said bad. He is not guilty, and 67% said not sure. There is reasonable doubt, which is kind of close to not guilty, but that's reasonable doubt. That's a big percentage. Appreciate the participation, family. We're going to keep it rolling. Let me see what else I got ready while they taking they little 5-minute break, which probably going to be about 10 minutes. You know how they do. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. Shout out to our stream sponsor, Allie.
The absence of evidence is not the evidence of absence.
What?
Y'all show us some love. Drop some coins in the chat. We're going to keep it rolling. Let me pull something up real quick. got some more stuff. Let me see. It's the lady that testified.
L-E-B-U-R-Y.
Thank you.
Dr. Scantleberry, where are you currently employed?
At West Tennessee Regional Forensic Center.
Okay, and what's your position?
I'm an assistant medical examiner.
And how long have you been in that position?
5 years.
I know she just testified, so I'm gonna just play a little bit of this while I'm grabbing this other clip.
Okay. And what does your job consist of?
Performing autopsies.
Okay. So could you tell the jury a little bit about your educational background?
So I attained my Bachelor of Science in Biology at Howard University. After that, I completed my medical training at Howard University College of Medicine. I did an anatomic and clinical pathology residency. Yes.
Did you take pictures?
Yes.
Okay. I'm actually going to hand these to you one by one. Can you tell me what you see in that picture?
So this is the right side of the head and neck, showing a large wound on the right jaw.
Okay. You can place that one down.
So because these have been previously marked, I need to know which one you're sending.
Your Honor, this is actually going to be exhibit number 16, previously marked. And now as to the exhibit number 17 that has been previously marked. Dr. Scantleberry, can you tell us what you see in that picture?
Yes. This is the back side of the body, noting mostly highlighting the right back with several wounds, and some wounds are noted on the left side of the back as well. And you can see the wound on the right jaw.
You can place that one down as well. As to exhibit number 18, could you tell me what you see in that picture?
So this is a front side of the body, highlighting the left side, and it shows some gunshot wounds here.
Okay, you can place that one down. And as to exhibit number 19, what do you see in that picture?
So this shows the right wrist and hand and a little bit of the forearm, and it shows some gunshot wounds. This one mostly highlights a wound at the right wrist.
Okay. And this is exhibit number 20. Could you tell us what you see in that picture?
So this is a wound of the left forearm right here, and it shows a gunshot wound of the left forearm.
Okay. And exhibit number 21. What is shown in that picture?
This is an overall picture of some of the clothing that was removed from Mr. Thornton.
Okay, you can place that one down. And exhibit number 22, is this also some of the clothing?
Yes. This is a shirt, and it has some markers that indicate where some defects in the clothing were found.
Is that the front or the back of the shirt?
I'm not certain, but it looks like the back.
Okay. And you can place that one down as well. And exhibit number 23, what do you see in that picture?
So this is the front of a shirt, and it also has some markers indicating where some hole defects were found.
Okay, you can place that one down. And exhibit 24.
This is an undershirt with markers showing where defects were found.
Okay, you can place that down. And exhibit 25.
This is overall of some property that was found on Mr. Thornton. It has money, some jewelry, some cards, and a condom.
Okay, place that one down. And exhibit 26. What is shown in that one?
This is an overall view of bullet fragments from the right jaw that were recovered.
Okay, you can place that one down. Your Honor, we are asking that those photos that have been previously marked be entered into evidence.
We'll mark exhibits, we'll enter into evidence exhibits 16 through 26 that have been previously marked and identified by this witness into evidence. Have you not done it already? Thank you.
And if I could have those pictures back. Your Honor, may I have permission to publish to the jury?
Judge, may we be briefly approached?
You may.
So this is the top of his head. This will be his torso here. This is the right side of the body, his ear. And this large defect here is a gunshot wound on the right jaw. And this is, well, I can't really see it that well, but this is the placard with the scale and case number indicating which case it belongs to.
So for this wound, did the bullet or bullets hit anything as it passed through the body?
It did.
Okay, what exactly did it hit?
It struck the skeletal muscle and caused a lot of fractures to the mandible, the lower jaw, and it caused fracturing around the gums where the teeth are located in the lower jaw.
In your medical opinion, would this wound be catastrophic or fatal?
Potentially.
Okay. Move on to the next one. And just for the record, Your Honor, I am going in order of the exhibits.
Thank you.
This is exhibit number 17.
It has now been 6 months since the murder of Memphis-based rapper Young Dolph. He was gunned down in November inside Makita's Cookies in South Memphis. Now in March, the business decided not to reopen its Airways Boulevard location. Not far from the scene, a mural of Dolph was created on the side of a store at Castalia and Boyle. Well, those two locations have become a place for people from all over the country to come and pay respects.
I see a remembrance of an individual that made the most biggest impact on everybody. For them to have all this and want to come back to it for him, I think that's beautiful. He was
It started with
obviously a well-known individual who made a very big impact on everybody. For them to want to come back, I think it's wonderful.
Well, Justin Johnson and Cornelius Smith both arrested for the shooting. Both men are scheduled to appear in court next week, where Smith will learn if he'll get bond. Shondell Barnes, seen right there on your right, is still at large. He is wanted for allegedly helping the pair evade police.
It's floor 8.
Yes.
What floor does Justin Johnson, who lives there, is that correct?
That's correct.
All right. Y'all collected videos?
We did.
Let's start with the first video. Let's stop over the light screen for me. November 16, 2021. This is the day before the murder, is that correct?
That's correct.
7:15 p.m. So if we're counting down, 17 hours and 8 minutes before the murder. What's that?
That's the white expedition, Ford expedition, going into the garage.
And if you're not familiar with the building, this is a little confusing here. You can pause it. So that white expedition was going into a parking garage, is that right?
Yes.
That parking garage is this structure right here.
That's correct. Parking lot in between.
There's a little parking lot here where cars can also park in, but the actual garage, what we saw the white expedition coming into, was over here.
It is.
Is that right?
That's right.
Then there's this little walkway thing that twists around and then comes into the building.
Yes.
Okay. And we see somebody here, gray sweatpants, black hoodie. We continue to watch. Inside of the building?
Inside of the building.
Walking into the door there?
Yes.
White expedition arrives, and then this man comes into the building.
Correct. Dark hoodie, gray sweat, black shoes, white bottom.
He walked here, and then this camera picked him up. There's a bank of elevators back here.
Yes.
There's apartments on the top floors of the buildings.
It is.
Still way back here at the elevators.
Yes.
Stop it there. Good. All right, here's a man, white expedition, comes into the building, walks to the lobby, gets in the elevator, comes up to the floor. Look, it's floor 8. What floor does Kiana Hopper's cousin, Justin Johnson, live on?
Which is ID is 808.
Yes.
8th floor.
8th floor. And this man has on black shoes, white soles,
You can go back on the record.
gray sweatpants. A little.
Yes. Jurors enter in courtroom.
What up, Daniel Berry Sports Highlights? What up, TSC? I see y'all. Appreciate you joining.
Ladies and gentlemen, I want to thank you for your time this past week. You've been stuck in a hotel room with no TV, no internet, just to make sure that your mind doesn't get jaded with regards to anything you see on the press. We talked about first appearances. I also talked to you about the fragility of the criminal justice system, and I hope you can see why now. I don't know anything about the 16 of you, which 12 are going to be the actual jurors. Mr. Govan doesn't know. I don't know if you have kids, if you're rich, if you're poor, if you live in Orange Mountain, if you live in a nice part of Memphis. You see that? I'm from Atlanta. But all I have is trust in you because you said you are peers to Mr. Govan. Mr. Govan, stand up. Come sit at the table and let them see you. It's time you're not marginalized anymore. Sit there while I talk. The fragility of the system is solely based on you. I don't know in what world the prosecution is living in this case, because unless they were watching something in the multiverse where other witnesses were saying perfect things, I don't know why we're here. You all should be embarrassed as a community that your district attorney thinks this evidence is sufficient to take a man's life for first-degree murder. You should be embarrassed that this is the person you voted for that brings this type of case. Just embarrassed. Many of you said you had a problem with the criminal justice system because too many people go free or they get bond. What they don't tell you, what the government doesn't tell you and the press doesn't cover, is this is what happens when you don't have an advocate that knows what the hell they're doing, checks all the records, fights for you, and shows you that he didn't do it. That's just another black man that is of no value from Orange Mound, that's poor, that has never had a voice in his life. I'm fixing that. My team is fixing that. He is indigent, he is poor, and he deserves better than he's gotten in this case. Sergeant Browning, who's the biggest liar that I'm going to go through with you, says we can't kidnap people and bring them in for questioning. What did Angela Arnold tell you? They threatened to have me arrested, being involved in this case, if I didn't talk to them. We went to the airport and we figured he was going to assert his rights, so okay. What about the second guy, Mr. Sears? His lawyer said he wasn't in town. When you talk about accessories and all this other stuff that the judge has told you about, how about the people that helped hide them? How about the people that helped give him new clothes? How about the people that gave him medical treatment, assuming they were even shot? Because you know what? I don't even know if he was shot, and I don't even know for a fact if that was the Mercedes used in the murder. Because why? There was no blood in the Mercedes. Had there been any blood to back up what Cornelius was saying, they would have plastered it front and center to you. Their own lieutenant from crime scene that they did not call tells you no one wiped that car with bleach because luminol or the other star thing, whatever it was, would show that. And if somebody said, I poured bleach on a towel and I wiped that car down, they would be alive. I don't know what world we live in. None of you would buy a pack of gum based on the word of Cornelius Smith. You wouldn't do it because he's a lying piece of so-and-so that will do anything. Lie to his pretend grandmother, his family, his girlfriend, anybody. And I'm going to prove it to you as we're going to go through a few more slides. And Detective Browning may even be worse because that's just pure evil, trying to put people in prison based on shaded evidence. Dabney told you the truth, that we didn't do all this other stuff that we should have done. We didn't get around to it, was his quote. He wasn't happy about it, but he told me the truth. The other guy couldn't answer a yes-no question. It was always dodge and deflect, which is what they're taught to do as part of their training when they go and come and testify. These are the people that are policing your streets. You should be ashamed. The only crime that's being committed here today is in this courtroom. It's been committed for the last 3 days. This poor man will never get his life back because of what's happened. He's been threatened because they all think he's involved in the Young Dolph murder and everybody loves Dolph. Dolph has been threatened for years. He moved away from Memphis 5 years ago. He had 3 old bullets in his body from other times he'd been shot at by people, being in Charlotte, being in Los Angeles. Everybody knew there was a price on his head. There is no plan. There is no plan. I tell you why? Because if I made a plan and I go back to my house across the street with the murder car, are you freaking kidding me? And then they go ahead and call around to see where can we go to get changed. We are across the street from the guy that planned the murder. We don't go to his house to change clothes, but we ride around town until somebody picks up the phone, as you see from the records, and we go to 2 Lane while we're bleeding and doing everything else. Have you seen a single photo of Angela Arnold's car, the Mercedes, or anything that had a drop of blood in it, as if they said? Cornelius is a pathological liar. I don't even know if he got shot on that day, because you have to ask yourself. There is a bullet lodged in his shoulder, as he told you. For a freaking month, he didn't get infected. He didn't have a problem. He just put some bandages on it, and it was okay. Please, for the love of God, this is insane that I even have to talk to you about this. If this is what is sufficient evidence for first-degree murder, we're all in trouble because you're going to be next. Assault, all these charges they gave you, there's 15 different ways they're trying to convict this guy. I didn't assault anybody. He didn't assault anybody. He didn't aggravated assault anybody. He didn't solicit anybody. He didn't facilitate anybody. He didn't act at whatever ate anybody. It didn't happen. All the text messages, all the phones, everything that showed you. Have you seen one single message from Justin Johnson or Cornelius Smith that says, hey, bro, let's go shoot somebody? I gave you tons of messages over their objection where Justin Johnson is talking to other people, talking about killing people. They weren't discreet about it. Where is a single message to Govan from any of these people over the course of 4 months that says we're going to do this? Can we get your permission? We're going to give you $10,000 or $38,000 or $50,000 or $100,000 or $1.5 million. You think if they would have had it, they wouldn't have shown it to you? They know the truth is the text messages are only about music because he's friends with Justin. I'm sorry Justin's not a nice guy. They all live in the same neighborhood. They've all known each other. Just because you have, quote, communication doesn't mean you're in a conspiracy to kill someone. Cornelius. Let's go over the slides. This will speak for itself, and I'll let you think about it because I've hammered the point about didn't prove it. I don't need you to say he didn't do it if you don't want to, but they absolutely, for God's sakes, didn't prove it. Let's go to the next slide. All right, so, excuse me. So you see this, what the government says? Angel Warren's phone? Absolutely. This is Star Defense Exhibit number 1. This C bruh, assuming C is Cornelius. Send me bruh number so I can get my phone, right? He needs to get his phone. Next slide. Quez's number. Guess what he told you is the one honest thing he said. His brother's freaking name is Marquez Smith. They call him Quez. His brother is the one that got the phone at best. You know why? Because they had TBI Gardner up here. They asked him to do location data analysis on the phone, right? You guys remember all that? And they did it solely for Cornelius' phone, and they did it for Justin's phone. But yet, they didn't show you any location analysis. All they have to do is say, it's in that general area, this is where the tower's pinging. Because calls are being made. Where was this call from? Where was his brother Quest? They just BS you constantly, and here I am fighting for this man's life. He is your peer. You need to be here protecting him from this. This is the crime. Next slide. So I'll just go over a few things on Cornelius Smith. I think that was pretty obvious from his statement. Go ahead, Robert. I think all this is obvious. You got a sociopath on your hands that's out there on his daughter's birthday. Is he intoxicated? Is he not intoxicated? Just ask the prosecutor to tell you a straight answer, honestly. Do you even think the prosecution would take advice from Cornelius Smith on anything? But it's good enough for this poor man's life. My dad used to tell me, you know how somebody's honest? Would you loan him money? Raise your hands if you're going to loan Cornelius money. Because that's the crux of the whole case. And a bunch of BS cell phone records that don't tell you anything. Because they didn't do the location analysis. They can't give you a single text message that says we need to do anything. And we know it was at least 4 months between the so-called meeting between multiple shootings that Cornelius did and when Justin went out. Next. And if you're not biblical, I'm sorry, but growing up that way, it's just used to be told the truth never changes. You don't need to remember it. You don't need to practice it. Why were we meeting with prosecutors and the lawyer just now report? I don't want a deal. I'm just here out of the goodness of my heart. I'm going to get a mandatory life sentence. Insane. Next. We also showed you the letters from Cornelius that he sent to his sister saying, I've got that lawyer that you're paid for. It's this guy's lawyer, and that guy cooperated against somebody else and walked from a murder. That's what you have in black and white in Cornelius' own handwriting. And that is what all of you said when I said, what would you do to avoid a life sentence? You guys said, probably anything. All right. We know this to be true. Next. And we know all this to be true. Next. And we all know this didn't happen. It just didn't happen. His story just didn't happen. And both he and Angela said it. Because, remember, he had talked to his family to go see Angela between the 14th of December, her first statement where she didn't know nothing about nothing, and the 17th of December when she's decided. And note how they have to prompt her to ask, could it be somebody with the name Q? And note, they had to ask her, didn't he forget something? Didn't he tell you something that he might have forgotten or something that he needed? They had to prompt her. This is 30 days after that. You don't have to remember the truth. This was the biggest day in somebody's life, you would think. I just killed Dolph. I'm running around, and she can't remember who the guy was that picked up the stuff at pressure room. Oh, shocker. There's a few cameras at pressure room. They had the absurdity to tell you, well, do you know how long the camera might be working or how long it records? You know how to find that out? Maybe go there and ask them. We've had Ring cameras and other things like that for a decade. It always goes to the cloud, and most likely it's going to be preserved for a year or so, which is what most businesses would do, especially in a dangerous part of town. And guess what? You have those crazy MPD cameras everywhere. You drive home, you'll see them. It's got the little blue thing coming out of it. I've showed you some of those from right around the area. Nobody checked any of them. You don't have to take my word for any of it, because everything I'm going to tell you is going to be backed up by independent evidence. You don't have to trust me for anything. You don't know me. But I want independent proof before I get in bed with a murderer with a machine gun that shot a guy 20 times in broad daylight, and thank God he didn't kill anybody else in that cookie shop. And this is who they're in bed with. Next. All right. Sorry, I just have to calm myself down. The other things with the shenanigans, as they try to tell you, is when the officer accidentally said, I don't even know if it was Justin something, I think he said that, but he said, AKA Dolph, I'm sorry, not Dolph, Grot, in that. And Mr. Cornelius says, yeah, I met him through miscellaneous in a moment of weakness. And you know, when I asked about it, how you smiled. You have murdered somebody, and we're up here chuckling. The government's chuckling with him, and he's laughing at me, making smirky faces, and says, I saw you on TV. That's the behavior you want from a guy that took a machine gun and murdered people. In fact, his definition is, I didn't shoot that many people because sometimes we didn't get the shots off or the gun yet. And you're going to make a deal, not a single text message anywhere, take my word for it. And oh, by the way, I think he's a federal snitch, but I don't know if I believe that or not, because he's never snitched on me. All right, next. And then he also tells Uncle Ron, maybe we should have gone and talked to him, whoever Uncle Ron is, yeah, but I'm not a policeman, and I'm not trying to put anybody in prison. That there was a bug on him, that he's a snitch, and so you're going to have to plan a big old murder. Next slide. So we know he paid for his lawyer, and we know that was a team issue, and you know the absurdity of the prosecutor in the last statement. They're going to get to go up again and call me every kind of name in the book, which is fine. I can handle it. I will take those arrows for this man that I've grown to care about over the last year and a half, because he didn't do it. They had the audacity to tell you we can't indict somebody that's dead. Shook died 2.5 years after all this happened. Remember, Justin Johnson was indicted in December of 2021, about a month after this happened. Cornelius was indicted in January of 2022, about a month and a half after this happened. There is no investigation done in 2023, or essentially 2024. It was done. They indicted and gotten who they wanted. So at some point you got to ask yourself, what happened here? And I have no idea, but it's not my burden to prove their screw-ups. If you believe Cornelius, he says Jook is the one that set it all up. His girlfriend says that. Then they backtrack and say, well, he was there and he set it up, didn't go there. None of it happened. Keep going. And with Miss Arnold, I don't know how you date a murderer that's been domestic violenced me, stolen from me, done this. I don't know what her issues are. I fault her not. She's just doing what the man's telling her to do. They've had visits, they've talked about it, and her story's still iffy as far as that goes. And God bless her. I hope none of you would be with a essentially soon-to-be convicted murderer for 4 years after all this happened. Right, next. And the interesting thing there was, we keep talking about the car on Bradley. Bobby Carter also lives on Bradley, and Bobby Carter was involved in the shootings with Mr. Cornelius. And in fact, Angela says Bobby was involved in the Dolph shooting as well. Next. All right, we already know this as far as the jail calls and the family coming to see her. Next. And we also know about the varying amounts of money this whole thing was worth. So now we get to the meat and potatoes of a few things I want you to consider. Remember, the two pillars to this case is you got to believe Cornelius Smith, and the judge has told you over and over again, you have to have that agreement. You got to believe it's out there, otherwise nothing. They've come up with 15 different methods, from murder to second degree to 30. I don't care if it's 47th degree murder. None of this stuff happened. There's no assault. There's no solicitation. There's nothing. So let's talk about the detectives. Next slide, please. All right, so the Detective Browning, the all-powerful Detective Browning, told you that Govan last talked. Oh, I'm sorry, I got my slides mixed up. We know Dabney, who actually I respected and had a nice talk with. He said they didn't do it straight up. Didn't try to sugarcoat it. We just didn't do it. Didn't go to pressure roll to confirm anything this man was saying. Tells you straight up we didn't go to AutoZone. Tells you straight up there was no relevant evidence of AutoZone. So this mystical receipt that's all crumbling, you can't tell what it is. That's supposed to be some kind of evidence now. And they didn't get around to investigating Joe, who was on Team Cornelius or whatever you want to call it. At least he was honest enough to tell you that. Next. So these are the slides you saw yesterday with Detective Browning. And this is where the evil of it all comes in. He did these call detail records for you. And this slide cuts off at 11:16 at 3:01:17. Right? They stopped it right there. I've highlighted for you. That was the slide. You might wonder, Manny, what's the big deal about that? It's just some phone call to somebody, no biggie, right? Yeah, he's talking to Cornelius here, no problem. But guess what? If they would have given you the full story on the slides where they turn bias you, next slide, you see on the same 11:16 at 5:37:15, this is Jook's number, and he spent a 6-minute phone call. It's not on the slide. I had to pull that off the call data record that you're going to have a thumb drive. You will never find it or see it because there's thousands of pages of call information out there. But you see, this thing stops up there at 3 o'clock. They don't tell you this part. That Justin Johnson talked to Jook before the murder and also sent him a turkey emoji. If you are a law enforcement officer, your job is to investigate and the facts go where they may. You don't have a job to convict people. That is why I respect Dabney. He made a mistake, he owned it. Browning is a liar. Pathological liar through and through. Next slide. So okay, this where Browning also told you that they last talked to Govan on November 5th. You remember an opening statement that told you Justin Johnson had not talked to Govan for at least 2 weeks prior to the murder. No communication whatsoever. But they try to tell you that, oh yeah, on November 5th, he must have talked to Govan. And then Cornelius last talked to Govan on November 15th. Just remember those. It was very specific that they argued. So let's go to the next slide. So what you'll see is, on November 5th of 2021, this is Govan's number. Hernandez Govan. He's getting a call from Justin Johnson. You see this? This is the communication they had on November 5th. How many seconds is that phone call? Let me break it down to you. Zeros. It never went through. There was no phone call for at least 2 weeks. No text messages. Nothing. And this is the guy I'm supposed to be planning a murder with the most famous person in Memphis. Are you kidding me right now? All right, next slide. So there's an old movie that said the tail wagging the dog. You've got Cornelius telling him what they want to say as he tells you he likes to do. And everything they're trying to do is back up what Cornelius says. There is no explanation why they didn't go talk to Jook or bring him down for questioning. There's none. There's none. All right, next slide. So just go through here. That's 10, 12 phones out there. Go through all of them. Find me a text message where a single human being tells Hernandez Govan, we need to do something. That's evil, that's violent, that's criminal. Browning told you he just came up with these slides just a day or two before all this happened, because this is 4 years after the fact. And I'm seeing the slides for the first time. And the slides are complete BS, because they keep misleading you about stuff. And so if the incriminating text existed, they would have showed them to you. They've cut off records in half, so you can't see the rest of the story. Go to the next slide. We know he agreed with me that these text messages, there's thousands of them with Justin Johnson. It's about music, because Justin was in videos and all that stuff, and Govan was there. He was a colleague, a friend, whatever you want to call it. That doesn't make you a murder criminal. And we know he talked to Cornelius about pills. 14 communications is what they call it. What they don't tell you is how many of those 14 actually went through. What were the phone call codes? Remember, 11 is important because that goes to voicemail, or it could be two-way, or the call goes through properly. Is it a text message? I don't know. Last night I'm talking to my daughter just about her boyfriend. Between okay, yeah, no problem, I had 16 communications with my daughter in a span of like 3.5 minutes. It doesn't mean anything, and you can't presume you know what the communications are about if, in fact, for the love of God, they even went through. I've already shown you one bald-faced lie by the government right there. There was no call on November 5th. Keep going. So we have the turkey emoji, we have the 6-minute phone call, and you know this secretive plan, PRE, as his bodyguard told you, this is social media. They do this every year. This is what they do. Remember, he's a man of the community. They put it out there. Everybody knows they're doing turkey emojis every year. Most of you probably know about this. Next. All right, skip this. Let's go to the next one. And then we have this. It's not anything I could get voluntarily out of that man. We had to press and press and press to show that Justin Johnson already knew Joe. Didn't need our guy to do any of it. That is why you will never see a single text message of any incriminating nature. Because I can promise you, had it said anything, a comma out of place, they would have it plastered up here on a board and saying, see, we got him, we got him. Next. All right, so Garner, he said, MPD asked me to do what? Location analysis on a couple of phones, Justin's and Cornelius's. All you have to do is plug in a number on a computer. We could have done it. Hey, it's also pinging off pressure wounds. Maybe more believable. Even if you choose not to go there, you could just ping it. You don't need the actual phone if you've gotten rid of it, because you can just order the CDRs from the phone company, as he told you. He did cell phone tower analysis for a very short amount of time, and then it just stops. Is this kind of investigation in Memphis we call sufficient to put somebody in prison for life? And none of the other phones were done. Where was Juk? Hell, where was anybody else in this case? Right? All right, we've got this, so covered that. Go next. We covered the AutoZone thing. I just respectfully ask, if the audacity to put a crumpled receipt in front of you that you can't read and just say, Detective Brown, I just know this now. It is not mentioned in any police report anywhere. As I asked him, he couldn't answer the question. But now suddenly it shows up in the phone. We know Dabney knew this was garbage because they talked about the auto part from earlier. You can't put a date, time, place on it. It's all what they call red herrings to mislead you. Think there's something nefarious out there and just use your imagination to convict people. You would never let this happen if it was somebody you cared about when you saw this. Some of you might be supervisors. If this half-ass work is what they brought to your desk, you would fire that person immediately. And don't say you wouldn't, because you would, because it makes you look bad. This whole county is a freaking embarrassment with regards to this trial, and the whole world is watching, and this is what we've got. All right, next. And then the last thing is you got to ask, if I set up the plan, I don't know if I'm having the murder car come to my house. And if I am having a murder car come to my house, why don't people just come inside and change clothes there instead of riding around all over town trying to find a place to go change? And again, I know you may think I'm crazy, but there's no blood in that car. Was this even the right Mercedes as far as that goes that they got? You remember Treon Ingram and another gentleman had stolen that Mercedes a while earlier. Treon Ingram didn't come and testify because Treon Ingram picked up another murder right after that. Where did the blood go? Cornelius told you point blank, no ifs, ands, or buts, and his girlfriend, I took bleach and I wiped it down. And the lieutenant from CSI with 28 years of experience says that just didn't happen. Where's Angela's car? Remember, she said he was bleeding all over. Where's the evidence of any of that? All right, next. So all I do is cross my hands and beg you guys, he is your peer. There is no evidence here. You would never accept what's happened in this courtroom in your own personal lives to make any decision of any kind. And he deserves that same respect. There is nothing here. They're going to get to come back up again. Remember, we talked about first impressions. You need to use your minds, your eyes, your ears, and your noses and call the sniff test BS on this whole thing that they're about to give you yet again. There's nothing here. There's no solicitation, there's no facilitation, there's no assault, there's no murder, there's not a text message, there's not a phone call worth a damn, and they aren't telling you the story. Make them tell you, why didn't we investigate Chuck? Make them tell you, why didn't we investigate all the people that helped these folks escape? And if you want to talk about conspiracy, how did he conspire or solicit Justin Johnson? Have you heard anything about that? Who's Jamarcus Johnson? Have you heard a single word out there? They're all together in a conspiracy. All you have is Cornelius' word. He's the linchpin of this whole case, and none of us would trust him. And we sure as hell wouldn't loan him money. And then we have phone records that actually exculpate him. But if you make it all nefarious and have a sleazy detective get up there and talk about it, it sounds pretty good. He didn't do it, but you don't have to take my word for it. He didn't prove it. If this case gets a conviction, then I just need to stop being a lawyer because the system is shot to hell. Thank you.
The absence of evidence is not the evidence of absence.
What?
Yo, big shout out to TSC for the gifted membership. Joining the sponsor.
Are you kidding me right now? Spencer just called the whole city of Memphis stupid and dumb. Everybody from the DA to the police officers to the prosecutors, he called y'all dumb. Called everybody, all one of them dumb. Are you kidding me right now? This case is not about the prosecutor. This case is not about Juke. This case is not about Justin. This case is not about Cornelius. This case is about Hernandez Govan. He is the person on trial, not the city of Memphis, not the DA, not the prosecutors, not you, Hernandez Govan. That's who we are here about today. That's what this proof has been about. Embarrassed. Who should be embarrassed?
You should be embarrassed for yelling at the jury like this. What the hell wrong with you?
Hernandez Govan. He is the person that made the choice to get engaged in this conspiracy. He made that choice. We've talked about choices. There are a few things in life that we can control, and our choices are one of them. What choices did Hernandez Govan make? You've heard that over the last few days of the choices that he's made. His choices led us here today. All right, police, they say they didn't do a good job. Convenient story. Something, novel. Because they didn't arrest everybody has to be arrested for them to do a good job. There was a twofold investigation. Sergeant Browning and Sergeant Dabney both told you that. It's very convenient that that part was left out of the defense's argument. There's a twofold investigation. Homicide and MGU. Those are two different entities within the Memphis Police Department. There was an ongoing investigation. And as Ms. Williams mentioned in her closing statements, this is a conspiracy. It's ongoing. To let you know that they were still investigating, look at the call records. Look at when those call records were received.
Now, defense will have you believe that, there are thousands and thousands and thousands of pages of call records. There are. But guess what? You'll have access to all of that, and they're on a flash drive. You can search. You can put in the numbers that were given to you, when things happen, what happened with those calls. They're there for you. There's no hiding. There's no putting them aside. They're there for you to look at. So I wanted to clear up that misstatement. The focus at the time of the incident, November 17, 2021, was on a homicide. It was not on who went to AutoZone or who went to Pressure World. The focus was on a homicide. A person was dead. The defense never mentioned that we are talking about a dead person. Dead. It's everybody's issue and fault but Hernandez Govan. The police didn't kill Adolph Thornton. Cornelius and Justin killed Adolph Thornton. But who put them together? Hernandez Govan. Look at the PowerPoint presentation that Sergeant Browning provided. It has communications that contact log was put in there for Juk and Justin on the same day, about July 27th, around that time. They looked like they exchanged numbers. And if they knew each other before then, they wouldn't have had to exchange numbers. They would have already had each other's numbers. Look at that. Look at the call detail records of Cornelius Smith. You'll see about the first time he had contact in his phone anyway with Hernandez Govan was about July 25th, 2021, around that time. All you have to do is plug the numbers in. It's not rocket science, as he'd have you believe. Hernandez Govan put these individuals together. In Govan's investigation, Govan's role in this conspiracy, as far as MPD was investigating, really didn't start until Angela Arnold gave a statement. Now, if we are to believe anything Angela Arnold says, then we are to believe call records, which Sergeant Garner said they don't lie. They're the records. They are what they are. So we can't believe that. We're not supposed to believe Angela either. We're not supposed to believe anything that's happened. The records are what the records are. But they bring in Sergeant Coburn or Lieutenant Coburn. Officers are bad. They don't do a good job. But he wants you to, well, this officer did a great job. Just this one that we bring in. He did a great job. Cornelius will tell you, he didn't just get a whole thing of Clorox and pour it all over the car and wipe it down. He said he sprayed some substance on a towel and wiped. He was still hurt. It was in the dark. He was in a rush. He was scared probably that Govan was going to come out and shoot him or do something because he was across the street from his house. But you want us to, defense wants you to believe that all the officers are bad, they did everything wrong, except that part. The investigation was ongoing. Look at the call records. Look at when they were done. And you can still investigate. And because you want someone arrested tomorrow, it doesn't mean the evidence is all there. At this point, Juk is dead. Bobby Carter's dead. Joshua Taylor's dead. We can't arrest them. We're not digging them up from the ground. They are dead.
that point is dead. Browning just analyzed the numbers that were there. Garner said the records are what they are. They come from the phone company or from the phone. All Browning did was analyze it. To say, hey, these many calls came from this individual, this many contacts. That's all Browning was brought here to testify about. But because those records show Hernandez Govan communicating with the conspirators throughout the summer, throughout the fall, from July until November, well past November 17th, at least November 20th of 2021, oh, Browning's a liar too. And when all he did was analyze the records. The records were made by Mr. Govan. Defense also brought up that basically Justin Johnson had access to Juke on his own, basically. But we know that Govan made that connection. July 27, 2021. We know that. We see that in the call records. We see it. Govan already had Juke's information. Govan already had Justin's information. This was by July 27, 2021. Govan had Cornelius' information. Govan texts Justin address to Juke's smoke shop. And the contact was created between the two while they were there. But guess who did not have contact with Juke? Cornelius. He was a part of this conspiracy as well. And he got up here and he testified and he told you that he really didn't have much contact with Juke. Guess who he was communicating with? Hernandez Govan. That's who he was communicating with. And let's look at the definition of conspiracy. You just have to create that at least with just one other person. So if you take defense at his word that Justin Johnson had other conspiracies going on and this was something separate, Hernandez Govan was still egging on Cornelius. He promised to get Cornelius paid. Cornelius didn't have direct access to Juke. He told you he was trying to still get his money. December 2nd, 2021, he sent a message from Angela Arnold's phone via Instagram messaging. He said he couldn't just straight out put that, hey man, I want my money. I did what I was supposed to do. He said he sent him a message trying to get his attention. A week later, he's arrested. But Hernandez Govan was the link between all of them. Hernandez knew Juke. Even if it did, that's still being investigated. But if the entire hit came from Juke, it was communicated to Govan, who then put it out to Justin and Cornelius. Hernandez Govan did that. The defense also makes the assertion that for 2 weeks, Hernandez Govan didn't have any kind of contact with any of the people who did the killing. He didn't have contact with Cornelius. He didn't have contact with Justin. The phone records will tell you that that is not true. It's simply not true. The phone records are there. There was contact. There was contact the day before. There was contact the day before that. There was contact days before that. And even if they didn't talk on the phone, what is stopping them from walking to his house?
Communication is there. Doing everything to take away from the fact that this trial was about Hernandez Govan. And there's nothing that says, okay, if we don't talk within 2 weeks, that all of this is out the window. Nothing in the jury instructions that the judge gave you or read to you said, all right, this conspiracy ends if we don't talk in a week. This is not girlfriend and boyfriend stuff. This conspiracy was ongoing. Hernandez Govan is just trying to pull himself away at this point. But this, Justin and Cornelius, they were put together by Govan. It's been reiterated several times. All right, even if you believe what the defense says, say Justin was conspiring with others. Okay, two things could be true at the same time. But what we do know, that shortly before the turkey drive, Cornelius said that Hernandez Govan called him and Justin together and was like, hey, y'all know this turkey drive getting ready to come up. Y'all ready? Y'all ready to make this money? Y'all ready to do this? Cornelius told us that. The call records, they show that there was some communication shortly before the turkey drive, the week before Thanksgiving. And Govan just reminded them, this is your mission. This is what you're supposed to do. If you want this bread, you need to make it happen. You need to make sure that you take care of that bounty that's been out there. You need to make sure this is what you do. So Justin chose, even if there were other conspiracies, just if there were other conspiracies on the side, on November 16, 2021, Justin Johnson chose Cornelius. He chose Cornelius. The same Cornelius that he was introduced to through Hernandez Govan. That same day, Justin Johnson sent Juke a turkey text. It's the same text that defense has entered into evidence. He sent that on November 16th. The defense just showed you there was some communication with Juke on November 16th. On November 17th, again, the day of the murder, the day that Dolph was killed. Even if there were, again, other conspiracies, Justin Johnson chose Cornelius Smith to go on a hunt with him. He chose to go on a hunt with him. He chose him the day before. He chose him on the day of. And Cornelius Smith said the only way he knew who Justin Johnson was because of Hernandez Govan. He told you that several times. Then we talk about Cornelius. Let's talk about his testimony. Cornelius was the state's witness. Prosecutors are probably not going to be hard in screaming at their own witnesses. The point is to get the witness to talk so that you, the jury, can understand what's going on. They're a witness. Cornelius, at this point, has already testified in a previous trial. He has no reason to come in here and lie to you about what he did. He said and told you, as you watched the video of the murder of Adolph Thornton, he told you, that's me with the big gun that killed him. Now, if any part of that is, if he's to lie about, why lie about him killing somebody? That's where you lie at. He didn't lie about that. He told you
But I wouldn't have known Justin Johnson except for Hernandez Govan, and he put us together to get this done.
Lady Justice is blind. Everybody can get it.
The defense attorney, at least several times, that he was under the influence. You saw the video. Cornelius Smith was up there. He was high. Even the questions that were asked of him were confusing. And he told me, he said, I don't remember. I had taken some pills, and we learned you've been taking pills. So why at that point say anything different? Even Angela Arnold said he took some pills that day. Yeah, he may have been fine, but he told you, I've been doing this for a long time. It may not affect me the same way that it affects someone who doesn't take pills. But in addition to the pills he was taking, he took some Tylenol PM. Defense tried to make it seem like it was just, a headache medicine. But he was getting that edge. He saw the end of the road coming for him. He knew the marshals were behind him. He knew that. He's taking them pills. So they tried to get a statement out of him that day. He's all over the place. He's confused. Doesn't really say much then. But he gives a statement eventually. And he tells you on the stand what happened. How Mr. Hernandez Govan set all of this in motion. And defense, paints him as a liar. Cornelius said his game with the women. Well, Angela, she's still with him. Some kind of game. Letitia Jackson, his kid's mother, he had enough game where she took his phone. He handed over his phone to her the day he got arrested. And Miss Ferguson, the neighbor, she said, he's a sweet baby, just sweet as he won't be, just slow. He helped her out. She didn't have a bad thing to say about it. Said he didn't give her $500, or someone didn't give him $500 for Cornelius. How do we know Miss Ferguson is the neighbor that happened to? Live on the street, there's several neighbors. But he brings sweet little Miss Ferguson in, who had nothing bad to say about Cornelius. Cornelius, this testimony was backed up by Angela, by the evidence in phone records, by the murder. All of that is backed up. Okay, you have looks like an AutoZone receipt in a picture of it, crumbled up. You have access to the picture of their receipt. It was a picture that was in the phone that Cornelius took. It was in Browning's presentation. Look at the receipt. Blow it up. Stretch it out. You'll see that was taken, it looks like AutoZone, and it was a receipt from November 20th, 2021. In the end, all of this points back to Hernandez Govan. He got the ball rolling. He kept the ball rolling. He kicked the ball in the end. He introduced Cornelius Smith and Justin Johnson for the purpose of taking out members of PRE. One member of PRE being Adolph Thornton. That's where the conspiracy started. Again, all fingers point back to Hernandez Govan. Justin, Hernandez Govan. Cornelius, Hernandez Govan. Jook, as the defense keeps wanting to throw out, Hernandez Govan. And why go to Hernandez Govan house after they commit the murder? Because that was comfortable with them. No one ever said these were the smartest killers. They didn't plan on getting shot. That wasn't part of the conspiracy. When we get shot, we're going to go here. But they'd already had the getaway car at Hernandez Govan house. So they originally met at Hernandez Govan house back in July. If they would ever meet up during the time of the conspiracy, from June of 2021 until March or whenever they were arrested,
the evidence is going to show that anything that I may have said, they exaggerated it.
Go to Hernandez Govan's house. They're all in the video. Park your getaway vehicle, go to Hernandez Govan's house. Park your murder vehicle. Hernandez Govan, that's the person.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
Did not go in? Maybe he wasn't there right then. Maybe he was like, someone went down, I'm getting out. Who knows? But we know what happened. We know where they went. We know that the murder vehicle was parked there. We know that the getaway truck that they used to get somewhere else was parked in front of Govan's house. We know that. Even Cornelius Smith told you, Cornelius Smith told you that Justin wanted him to meet him on the day of the murder. He wanted him to meet at Govan's house. Cornelius said he couldn't get over there. So Justin came and picked him up. Again, all this going back to Hernandez Govan, as much as the defense tried to deflect and get you to choose different deflections, it all points back to Hernandez Govan. Hernandez Govan had choices. He chose to bring Cornelius and Justin together. He chose to encourage them to have a hunt, to go on a hunt. PRE members, but the biggest bounty was Dolph. He knew that Cornelius had a drug habit and that he needed money. And he played upon that. He preyed upon that. And he put him together with someone who was just as hungry for him. Justin and Cornelius were put together by Hernandez Govan. He chose to ask each of them for a cut of the proceeds. He chose conspiracy. Hernandez Govan chose murder. Adolph Thornton will never get to experience many of the things we take for granted in getting old. He will never get to experience gray hair. He will never get to experience wrinkled skin, crackling knees. He didn't get to choose to grow old. That was taken from him and put in motion by Hernandez Govan. You, the jury, you have a choice. The choice is now yours. You have a choice in whether you hold Hernandez Govan accountable for his role in this murder, for his role in this conspiracy. And I ask that you choose to find Hernandez Govan guilty of murder in the first degree and guilty of conspiracy. Thank you.
All right, ladies and gentlemen, I'm picking up on page 27.
Have a good night. Have a good night. Have a motherfucking good ass night.
In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. Verdict. Count 1. The charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder, solicitation to wit, conspiracy to commit first-degree murder, and accessory after the fact to wit, first-degree murder. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, solicitation to wit, first-degree murder, solicitation to wit, second-degree murder, aggravated assault, facilitation to wit, aggravated assault, accessory after the fact to wit, first-degree murder, assault. Count 1. When you retire to consider your verdicts, you will first inquire whether the defendant is guilty of conspiracy to commit first-degree murder, as charged in count 1 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of conspiracy to commit first-degree murder, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit, conspiracy to commit first-degree murder, as embraced and included in count 1 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least. If you find the defendant is guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, placing that offense in that blank, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 1 of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: We, the jury, find the defendant not guilty as to count 1. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. Count 2. You will next inquire whether the defendant is guilty of first-degree murder as charged in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be, we, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of second-degree murder as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be, we, the jury, find the defendant guilty of second-degree murder, including and embraced in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least. If you find the defendant is guilty of a lesser included offense, your verdict will be, we, the jury, find the defendant guilty of placing that offense in that blank, embraced and included in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 2 of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be, we, the jury, find the defendant not guilty of count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over the deliberations. When you have reached a verdict on a particular count, the foreperson will check the corresponding box on the verdict form and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. Now, there is a couple things you need to know. Pages 33, 34, and 35 are your verdict forms. So I kept referring to check the corresponding box. These are the corresponding boxes. You got count 1 and 2 pages for count 2. Okay? I also have here the official copy of the jury charge. There are a couple of minor changes that I've made, like I caught one misspelled word, a couple misspelled words, and I've made those changes on here. Nothing that's going to change it substantively. But the official copy is going to go back to the back. Please do not write on it. Feel free to write on your own copy. Just use this as the official copy if there's any discrepancy on what you may have with you. Okay, so this is the official copy. So is everybody in a good position to deliberate? No issues with the court needs to know about? All right, so we shall choose 4 alternates. Once again, all of the exhibits are going back to the back with you. We will be provided a computer, a blank computer that you can use to look at any of those zip drives if you'd like.
absence of evidence is not the evidence of absence.
Shout out to TSC for the super sticker. Feeling the vibes. Appreciate you, family. Just waiting for the proper break in between. Shout out to TSC. Y'all show her some love. Drop her some coins. Much love, TSC. And Allie. Stream sponsors of the day. Shout out to Allie and TSC. Stream sponsors of the day.
Stacey, do you have anything back in the back you need to collect? No. If you'll just stay right where you are, please. Miss Wilkes, ma'am, do you have anything back in the back? Mr. Cobb, do you have anything back in the back?
Just a book.
You want to go get it now? Mr. Ayers, do you have anything back in the back?
Getting ready to start the verdict clock, family. Almost time to start the verdict clock.
Write them down, and turn on the lights. And, Officer Parks will come collect the question. George, you are excused to deliberate. Officer Shango.
Start the verdict clock, 3:10, about 3:10. So we say about 3 o'clock. See how many hours it take. If they come right back, you know it's not looking so good. The longer it take, the better chance it is for them to get a not guilty. But the faster they come back.
All right, you can stand in recess. I always just show lawyers this. I had a bad experience one time, so I always show lawyers what the numbers are, make sure we are playing with the numbers. So, what you reading? All right.
So I guess they about to take a recess. We keep it open. I got something for y'all while they in their recess. Got a special treat. Y'all hit that like button, hit that subscribe, tap in, share with a friend. I got a little something. Welcome
to Flesh of the God.
Well, isn't this a nice surprise?
Efforts that she's making to supervise you. I gave a copy of that to Mr. Durham to his mind. She had given this about 2 weeks ago because she had some concerns. She's indicating that you're asking for some relaxed conditions on your bond, that you want some of the restrictions removed or want some of them lessened. And every time we come to court, Mr. Govan will get this request that says Mr. Govan is asking for other things. At first it started with, you wanted to go clothes shopping. I think my response was, you can have Amazon.com deliver your clothing.
Yes, sir.
You also wanted to go grocery shopping. I told you can call Kroger and they'll deliver your food to your house. And I also got a request that indicates that perhaps you want to be given the same consideration of some other.
And hold on. my bad, family. Before that, I got another thing exclusive. Shout out to Cha Diggy. Check this out real quick, family. Is Cha still? I think she rolled out, but check this out.
$1 billion proposal to fix the Fulton County Jail. Well, since 2023, 18 people have died in the county's custody. Atlanta News First senior reporter Patrick Quinn live from the jail tonight. Patrick, the Department of Justice now involved to address the crisis inside. How can this plan better protect the inmates inside?
It will specifically meet the needs. 70% of the current jail population. That's according to county leaders. And for those with loved ones inside, change can't come soon enough.
I need my child out of there.
Through tears, Karanda Locklear told me her son, Robert McGee, was booked into the Fulton County Jail last month for failing to appear in court. She believes he's wrongfully detained, and she fears the jail cannot meet his needs. She said he's diagnosed with mood disorder and has ADHD.
He need all his medications, he need pain meds, he need his mental health meds, and they cannot provide any of these services for him.
While McGee awaits a new court date, the county is set to vote on its latest plan to fix the Fulton County Jail to the tune of $1.1 billion.
There is no perfect plan, but at the end of the day, we're taking this step to move forward, and the time to make that decision is now.
Fulton County Board of Commissioners Chairman Rob Pitts said this plan prioritizes protecting those battling mental illness and substance abuse.
We're addressing the issue of staffing as we speak today.
The plan also calls to rehab the existing facility from top to bottom after a facility assessment found the jail's roof, interior, plumbing, electrical, and fire protection were beyond poor and were in critical need of repairs for the safety of the jail population. What's increased to nearly 3,000 residents, up by more than 200 residents since May. For some advocates, this new plan is a mere $1 billion Band-Aid.
Putting the cart before the horse. They continue to try to find ways to invest in carceral spaces and yet to put the necessary efforts into trying to reduce the population at the Fulton County Jail.
For Karanda, more needs to be done inside the jail to protect residents while she pushes to get her son back on the outside.
And that's all I have in me is some fight for my child.
$1 billion, family. They say they coming for that bill ticket. Not the meal, but the bill ticket. They ain't playing. All right, we gonna get back into it. Shout out to Child for that one.
Other folks, and that you think that you want to be permitted to go to work full time. Ms. Govan, you're on bond because all parties agreed to that. Those conditions were set by this court. Those were conditions that all parties agreed to, and I don't see any reason at all why this court should relax those conditions and tell Ms. Govan, we're going to let you go back to being a fully fledged person with no restrictions at all. Go to work when you want to, go shopping when you want to, leave the county when you want to, go to other places when you want to. Ms. Govan, you're on those restrictions for a reason. And part of those reasons is for your own safety. You are probably aware that Memphis, Shelby County, Tennessee is the first most violent metropolitan area in the country. This case has generated a substantial amount of publicity. And if you're running around free in Shelby County, Mr. Govan, knock on wood, somebody might be trying to kill you, sir. So it is not in your best interest to say, Judge Coffey, take away all these conditions and let me just do what I want to, go where I want to. And there have been some instances where you were allowed apparently to take a couple of trips. That can't happen anymore. Because of the conditions of this bond, that this court set this bond, and you can't deviate from those conditions unless this court tells you to do so. I'm told by Ms. Taylor that she's having some difficulties in supervising this bond because she had a couple of trips that were approved and was not approved by the court, were not discussed with the court, were not discussed with Mr. Handel Durham, and that's a violation of your bond, Mr. Govan. So I don't know who gave you permission to take those trips to leave Shelby County, but unless you hear from Judge Coffey, don't say anything else. Unless you hear from Judge Coffey and Handel Durham, your attorney of record here, Mr. Rohrer is probably not going to be in on most of these settings, but unless you're in court on the record with Mr. Durham in his court and Ms. Taylor and asking the court for some relief and say, Judge, I need to do certain things, will you please approve it? It cannot be done unless it is approved by this court, Mr. Govan. You understand that, sir? Yes, sir. And please, please, please stop asking Ms. Taylor probation management group if they can relax these restrictions, or if they can do certain things, or let you go shopping, or let you get a job, because she doesn't have authority to do that. Ms. Keller would do what the court ordered when I entered the bond conditions on this case and placed those conditions under seal. Those are not negotiable. They're not open to discussion. They're not open to change unless Mr. Durham files a written petition in court and says, Judge Coffey, I'm asking that you modify some of these bond conditions. Now, unless Mr. Durham asks for Mr. Govan to talk to Mr. Durham and say, will you please address Judge Coffey about doing certain things, he'll do so. But I think what Mr. Durham will tell you is that, Mr. Govan, you should be blessed that you are on bond. The only other resolution for Judge Coffey is to put you back in jail pending a disposition of these charges. Your lawyers have worked, yeomans have done a great job in getting you released on bond until these cases are settled. But I do not intend, and I want you to hear me clearly, I do not intend, unless there's a substantial change, I do not intend to change the conditions of this bond and say, look, I thought about this, we're going to relax this. So unless there's some earthquake can change, something that's significant, that says, Judge, something has come up, we're asking you to modify these bond conditions. Mr. Govan, the bond conditions that were entered when both sides agreed to release you on bond, those are immutable. They would not be changing, sir. They could get worse. They could get more restrictive, but they're not going to get any less restrictive, Mr. Govan. You understand that, sir? Yes, sir. Keep working with your lawyer. Give Mr. Durham, and Mr. Durham will continue to discuss your case with Mr. Manny Aurora. Give them anything that you want them to look at for you. Now, I'll see you back in court on Thursday morning, September 21 at 9. Any questions? No, sir. Mr. Govan?
I don't have to tell you how serious these charges are. I know I don't even have to go back through that. Right? I also shouldn't have to remind you that you're out on a bond and the court has put you under some real serious or some real tight stipulations.
Yes, ma'am.
At this point, the court feels like you're playing fast and loose with the court in these stipulations. Feels like you're serious or some real tight stipulations.
Yes, ma'am.
At this point, the court feels like you're playing fast and loose with the court in these stipulations. And I don't like that. You have filed a motion through your attorney asking me to review your bond conditions. And before we could ever do that, I get a message from a concerned citizen that you're out doing interviews. Whether you're talking about this case or not, you're doing interviews. And the court doesn't like the fact that you feel free enough to do interviews. Because what could be happening is that you could be in jail. And it's a whole lot easier to supervise you there. But you've been given the opportunity to post a bond with bond conditions, and you're not doing those things you need to do. We're going to review those bond conditions on March the 1st. But let me make myself extremely clear to you that you are to not have any interviews with anybody for any reason. Your attorney has assured me that nothing was said about this case in that interview, and I have no reason not to believe what he told me was true. But like I said, you should not be interviewing with anyone. You should not be making any public statements, and you should be in the house. That means not going to anybody's funeral. Put your hand down. You're speaking through your attorney at this point. Yes, that means not going to funerals or anywhere else. That means in the house as of right now. And about you not showing up on yesterday or showing up and then leaving because your counsel thought it was appropriate to allow you to go home because you were getting a barrage of phone calls, that's neither here nor there. When you're supposed to be here, you're supposed to be here. Were you not on my docket yesterday?
Yes, ma'am.
You were supposed to be here. Bottom line.
And I thought I was. He instructed me not to come. I was.
Like I said, you are supposed to be here. Whether your attorney is here or not, you should be here.
Well, that's ineffective assistance of counsel. If the attorney told me not to come, what the hell? Why would you bang on me? Like, where's he at? Why is he not in trouble? He told me not to come.
¿Qué puñetas? ¿Qué puñetas? ¿Qué puñetas?
Do you understand that?
Yes, ma'am.
Do you understand what house arrest means as of this point?
Yes, ma'am.
I'll see you back here on March the 1st, sir.
All right, thank you.
Please don't give me any reason to revoke this bond.
All
And
right.
then we won't even have to have these conversations.
Yes, ma'am.
What the heck? This dude was wilding, huh?
The museum takes visitors on a tour of Dolph's life through a variety of themed rooms, starting in a convenience store and ending at the cover of his album, Paper Route Frank, released after his death. His manager, and ending at the cover of his album, Paper Route Frank, released after his death. His manager.
Man, they got this dang music in the back.
Alan Parks says Dolphland is supposed to give fans a substitute for a tour in support of the album.
Yeah, they got too much music on there. We ain't gonna be able to get that one. Just a second, family. Appreciate y'all. Y'all hit that like, hit that subscribe.
Now to a top story. The search continues tonight for the man Memphis police and U.S. Marshals say is responsible for rapper Young Dolph's death.
Oh, we first showed you Justin Johnson's picture as breaking news last night at 5. But tonight, we're looking into his violent past. Fox 13's Dominic Dillon is joining us live from South Memphis. Dominic, what have you learned?
Well, Darcy, the big question is, why was this man walking the streets of Memphis in the first place? We did some digging and we learned that back in 2017, Johnson admitted to shooting 3 people. He was sentenced to 5 years behind bars, but as you can see, it's 2022 and he was a free man. 23-year-old Justin Johnson is wanted for first-degree murder. Memphis police say Johnson is responsible for gunning down rapper Young Dolph on November 17th. But it's not the first time Johnson's been accused of shooting someone at a Memphis business. We learned in 2017, MPD arrested Johnson, who was then 18, for shooting 3 people at Billy Hardwick's All-Star Lanes bowling alley on White Station Road. An affidavit says Johnson was a part of a large fight. It says he went out to his car, grabbed an assault rifle, and fired into the crowd, hitting 3 people inside the bowling alley before leaving. Documents obtained from the Shelby County criminal justice system show he pleaded guilty to 3 counts of aggravated assault in May 2017. The records show Johnson was sentenced to 5 years behind bars. But that November, less than 6 months later, records show a judge granted a motion to suspend the rest of Johnson's sentence. 6 months after that, he was arrested for gun and drug charges. Documents show there was a request to revoke his sentence, but it's unclear what happened. We reached out to the DA's office several times today to learn more, but have not heard back. Court offices were closed because of the weather, so that may be the reason we haven't heard back yet. While law enforcement searches for Johnson, there is another gunman in the surveillance images from Makeda's, and we reached out to MPD about information on that suspect, but we were told that when any new information is available, they'll update their social media platforms. Reporting live in South Memphis, Dominic Dillon.
What?
Shout out to the stream sponsors. Appreciate you, family. Let me grab something else for us to tap into. while they out there deliberating. We still got the live pulled up, so we'll see it as soon as they come back.
All right, 5:32 now, and a fifth suspect in the Young Dolph murder investigation is behind bars this morning, 3 years after his initial arrest.
Yeah, Shango Barnett. He was arrested in 2022 in Indiana with convicted killer Justin Johnson as Johnson fled Memphis after Young Dolph was murdered. Now Barnett's accused of helping him escape. Jeremy Pierre joining us live with details. Hey, JP.
Yeah, let me tell you, this arrest of Shango Barnett coming as a big surprise because even months after him being arrested by U.S. Marshals in Terre Haute, Indiana, we asked the Shelby County Sheriff's Office, the Memphis Police Department, even the Shelby County DA's office, if and why there happened to be a warrant still out for Shango Barnett's arrest. Well, after his arrest in Indiana, Justin Straight Drop Johnson, his cousin, he got extradited back to Shelby County where he faced his charges. As a matter of fact, in September, he got convicted by a jury. We asked those agencies what's next with Shango Barnett. Even though he still had a warrant out for his arrest, they said they weren't going to execute it. Well, this morning, we got our hands on the new information, and basically, according to court documents,
exclusive new information.
It reads that Barnett rented a gray Dodge Ram a month after the murder of Young Dolph from a rental car place here in Memphis, matter of fact, on Poplar Avenue. According to police, witnesses saw Justin Straight Drop Johnson leave in that Dodge Ram the night police went to attempt to arrest him here in Memphis. Barnett now facing accessory after the fact, first-degree murder, attempted murder, and theft. Again, Barnett,
being escorted.
according to police,
medical exam. And the car. Get the car. The car.
Rented a Dodge Ram for Justin Straight Drop Johnson. Now, since this arrest came overnight, Shango Barnett won't be in court until tomorrow. But you better believe this is something we're going to continue to keep our eyes on.
Charged in the murder of Memphis rapper Young Dolph.
Yeah, we'll be checking back on, and
you know, it was funny at one point when he was first.
Thursday is 1 year to the day that Dolph was gunned down.
Hernandez Govan is charged with first-degree murder, criminal attempted first-degree murder, and conspiracy to commit first-degree murder. According to documents obtained by Fox 13, those charges go back several months before Dolph's death, accusing him of arranging the murder. Court documents show Govan's last known address is in Orange Mound, at the same house where police found that white Mercedes that they say was used by the
just for them being them.
I know it's been a tough past few years for everybody. Just kind of talk to me about that also and why you're here.
I got a aunt, my aunt, she's currently here. Like, she has cancer. My grandmother had cancer. My uncle had cancer. And they all came through these doors. And I just wanted to show up and just really thank them for what they do. Because it ain't an easy job. Like, it's kind of hard, you know what I mean? Just seeing people in those conditions. Like, some people be more down than others. Some be all right. It's really just be all about timing. Like, even the ones that be all right, it's like it only lasts for so long, but they do a hell of a job. And I just wanted to come and congratulate them and let them know, like, they appreciate it.
Talk to
Yeah.
me too about, I know later on today you'll be giving away turkeys, so kind of just talk to me
My artist, Big Moochie, great. He's from the east side, he's from East Memphis, so we'll be in East Memphis, like everybody, we be passing out turkeys all over the city, like every part of the city this whole week, really. Yep. Not really, just the same, typical, same as usual. You know what I mean? Like, I appreciate all the love, all the support throughout the whole city. Appreciate the Item A Foundation. That's what we're doing it for. That's what it's all about. And really just showing love and spreading love. Yeah. My auntie love y'all, but my grandmama came here, my uncle came here. Like, I got like a family history.
They're just shocking. Come on, T. Get over here. All right, 1, 2, 3.
And as the news of Young Dolph's murder spread, people began showing up to the crime scene. An emotional time with people hoping against hope that the news was not true.
Man, they really took a good young cat away from here, man. It was good to the city. You know, it's good in the neighborhood. Always give it back to this neighborhood, always give it back to this community. And it's a great loss, man, for this city to suffer a loss this big like this, man.
Young Dolph, known for many hits, including Major, On the River. He released his debut album in 2016, King of Memphis.
He wasn't just a rapper, though. He was a family man. He had a wife and 2 children. He is known for giving back to his community here in Memphis. Every year, he gave out turkeys for Thanksgiving through Memphis Athletic Ministries. In fact, he was set to have a turkey giveaway tomorrow in the same neighborhood he was killed. Young Dolph also frequently spoke to school children, donated money to his alma mater, Hamilton High School.
Stay in control. If you're not in control, you're out of control. I live by that. You know what I mean? Nothing in this world stay the same forever. Everything happened for a reason. With that being said, like in so many words, be true to yourself.
Barnett, the man you about to see here, is from Memphis, but he's accused of helping Justin Johnson evade arrest in another state. He's now facing charges of being an accessory after the fact.
All right, on top of that, Justin Johnson and Cornelia Smith are charged with first-degree murder and a list of other crimes. U.S. Marshals teamed up with Memphis Police and the District Attorney's Office for an update today.
Yeah, we brought you that news conference live this afternoon. Authorities shared details of their investigation and what led them to Justin Johnson, as well as how Cornelia Smith had been in custody tied to the carjacking of a white Mercedes.
And it is that same Mercedes officers say was used as the getaway car in Young Dolph's murder. We now know that car was stolen from a woman at a gas station in East Memphis.
Yeah, police say they discovered Smith's fingerprints on the car. WREG's Shay Arthur tracked down the owner of that white Mercedes and has her reaction to the unfolding of this case tonight. Shay?
Hey, Stephanie. Hey, Greg. Yeah, as you can imagine, she said the last few months have been pretty tough. It was actually that car owner's relative that was driving the car at the time of the crime. She was actually on the phone with her when it happened. Take a listen to this.
As investigators searched for Young Dolph's killers, they looked for this white Mercedes. We've now learned it was stolen from a woman at this gas station off Kirby Road a week before the murder. The 22-year-old driver at the time, who made the quick stop just after 7:30 at night, had borrowed the car from a relative. We talked to that relative today. For safety concerns, she asked us not to identify her.
And I'm just so glad that she wasn't killed, because these guys are killers.
The victim told police 2 men armed with assault rifles came up and demanded the car. One of them hit her in the face with the barrel of the gun. The young woman called her relative as this happened. She didn't immediately give up the car.
When she calls you when this is happening, what is going through your mind?
I really thought they were going to kill her. I mean, that's all I was thinking. I'm going to hear.
The absence of evidence is not the evidence of absence.
What?
Shout out to TSC with the super sticker. Appreciate you, family. Y'all show us some love. Drop us some coins in the chat. Appreciate you.
her die right here on the phone. She's going off, and she was standing up for herself, and even at one point, kept them from possibly putting her in the car with them.
Eventually, the men got the car keys and drove off. A week later, a picture of the car is broadcast out, believed to be the getaway car in Young Dolph's murder. Then, days later, officers discovered it behind an abandoned home in Orange Mound. The victim's relative tells us the young woman still has anxiety from the incident.
A little trauma resurfaced just from all of it coming back up. It was really hard on her.
She says while she only had the Mercedes, her dream car for a few months, property can be replaced. She now thinks of Young Dolph's family as they deal with their loss.
My heart goes out to the people that were, hurt by this group of people that are not okay.
And reminds everyone tonight to always stay alert wherever they go.
Jr. You know him as Memphis rapper Young Dolph.
Yeah, and today folks are going to gather to remember Young Dolph. This morning, we take you back to our coverage on that day that he was gunned down at Makita's Cookies.
Hey, what's poppin'? It's the kid. It's Dolph.
That's all I came for to get some Makita.
Makita Cookies.
You know something wrong, you just don't know what it is.
We are coming on the air with breaking news tonight. Rapper Young Dolph is dead at the age of 36.
The news getting out. Young Dolph sadly lost his life.
Dominic and Fox 13's Jeremy Pierre are working to find answers.
Officers are trying to de-escalate the situation.
36 on the air with breaking news tonight. Rapper Young Dolph is dead at the age of 36.
The news getting out. Young Dolph sadly lost his life.
Dominic and Fox 13's Jeremy Pierre are working to find answers.
Officers are trying to de-escalate the situation.
And the car. Get the car. The car.
Emotions are high. Frustrations are high.
This will leave a hole in the hearts of people.
My Dolph dead? I can't believe it.
He gave money, he gave food to those in need, he gave support, he gave love, he gave comfort.
Someone who's so meaningful, who contributed so much.
And it's a great loss, man, for this city to suffer a loss this big like this.
A mega superstar from Memphis.
Other than being a superstar, that's somebody's child right there. That's somebody's nephew right there. That's somebody's father right there.
1, 2, 3.
It's down.
No questions.
Call Raul Hopkins.
Smith. Smith, good morning. Smith, we'll actually raise right hand your handcuffs, so I'm going to tell you've been indicted by the grand jury. Smith, you charged in indictment 22-00014 with the offense of first-degree murder. But Smith, that offense carries a sentence of life in prison. The same Tennessee could also file a notice to seek the death penalty or to seek life in prison without the possibility of parole. You've also indicted in count 2 of this case, Mr. Smith, in charge of criminal attempt to commit a felony 2 with first-degree murder. That class A felony carries anywhere from 15 to 16 years in prison. Count 3, Mr. Smith, charges you with being a convicted felon in possession of a firearm, alleging that you've been convicted of an aggravated assault. That's a felony with statutory elements involving violence and attempted use of violence. That B felony also carries 8 to 30 years in prison. This offense occurred after July 1st, 2021. That's an 85% sentence. Mr. Smith, if you're convicted of that crime, you have to serve 85% of that sentence. You've also been charged with employing a firearm in the commission of a felony offense. That C felony carries anywhere from 3 to 15 years in prison. The gun charge is a 100% sentence. Mr. Smith, if you're convicted of a gun charge, you have to serve 100% of that sentence would have to run consecutive to attempted murder. You've also been indicted by the grand jury and charged with theft of property. And that C felony carries anywhere from 3 to 15 years in prison. Mr. Smith, do you understand what you're charged with, sir?
Yes, sir.
Mr. Smith, do you have an attorney?
We're getting hiring on right now.
You are in the process of trying to hire an attorney right now, sir?
Yes, sir.
Who's going to hire an attorney for you, Mr. Smith? Have you talked to an attorney yet?
Yes, we do.
Do you know what attorney you're trying to hire, Mr. Smith?
Not at the moment.
Not at the moment. How much time do you need in order to get an attorney hired for you, Mr. Smith?
About another week.
You think you'd have a lawyer in a week, sir?
We're going to have 2 weeks, yes, sir.
Have a seat for a second. We'll talk to you in a minute, please, sir. Mr. Justin Johnson. Mr. Johnson, good morning, sir. Mr. Johnson, in that indictment 2103333, you are indicted for the same similar conduct, rather, let me rephrase that, as in 2200014, rather, you're indicted for the same conduct as your co-defendant, Mr. Cornelius Smith. Count 1 charged with first-degree murder. Again, that carries a sentence of life in prison if convicted. Life under Tennessee law, Mr. Johnson, is construed to be 60 calendar years. You have to serve 51 years of that sentence before you become eligible for release. Attempted first-degree murder carries 15 to 60 years in prison. Being a convicted felon in possession of a firearm carries 8 to 30 years in prison. Employing a firearm in the commission of an attempted murder carries anywhere from 6 to 15 years in prison. That gun charge is 100% sentence, Mr. Johnson. If you're convicted of using a gun, employing a gun in an attempted murder, you have to serve a minimum sentence of 6 years at 100%. Those sentences have to run consecutively. You've also been indicted for theft of property. That C felony carries 3 to 15 years in prison. You have a second indictment. That apparently was superseded by the other indictment, which I just read into the record. 1210333 charged for first-degree murder, attempted first-degree murder, and theft of property. Now, do you understand the charges against you, Mr. Johnson?
Yes, sir.
Do you have an attorney, sir? You're working on hiring an attorney. Mr. Johnson, who's going to hire an attorney for you, sir? How long will it take you to get a lawyer, Mr. Johnson?
I can't answer that. I don't know.
How much time do you want to continue your case so that you and your family can hire an attorney, sir?
2 weeks.
Mr. Johnson, if you tell me that Judge Coffey, I cannot afford an attorney, I will appoint an attorney for you. Do you understand it, sir?
I can afford one.
You can afford an attorney. Mr. Smith, stand up for a second also. Mr. Smith, if you tell me that you cannot afford an attorney, I will appoint a lawyer for you also. Do you understand it, sir?
Yes, sir.
You tell me that you can afford an attorney.
Yes, sir.
Mr. Johnson, Mr. Smith, you do not need the court to appoint an attorney for you. Is that correct?
Yes, sir.
And Mr. Smith, you told me you can have an attorney hired in a week or 2.
Yes,
Mr. Johnson, you told me you don't know how long it would take you to hire an attorney.
I don't know how my people got to do, they I don't know, I can't say.
When would you like to be back in court so you can let me know whether or not you were able to hire an attorney, Mr. Johnson?
About a week.
About a week.
About a week.
Mr. Hager, you handle this case with say Mr. Griffiths.
Yes, sir. Yes, sir.
You're both asking for a week, is that correct?
I should know something in a week.
Mr. Hagerman, with Friday of next week, the 28th of January, be the day for you.
That's just fine. Yes, sir.
Mr. Smith and Mr. Johnson, I'm going to continue your case until Friday, January 28th. That will give you about 90 days to see if you get a lawyer hired. Now, if you come back on Friday, the 28th of January, and you tell me that you cannot afford an attorney, I will appoint an attorney for you. I will appoint a private lawyer for you, somebody who's qualified to handle the most serious cases in the state of Tennessee. I will appoint a lawyer for you if you tell me you cannot hire an attorney. Now, I cannot let you sit in jail week after week, month after month without an attorney because it would violate your rights. You understand this, sir? Ms. Johnson, you have any questions, sir? Ms. Smith, you have any questions? I'll see you both back in court on Friday, January 28th. If you have a lawyer hired, that's fine. If not, I'm going to appoint an attorney for you. You can both step back in the back. Thank y'all for bringing Ms. Smith and Ms. Johnson to court for me.
We saw, but what exactly happened today?
Today we had the two defendants, Mr. Johnson and Mr. Smith, in court for the first time on the murder of Adolph Thornton, Young Dolph. It was set for arraignment. Both of the defendants asked for more time to get attorneys hired. They said we'll come back in about a week and a half for that.
You know, understanding that they don't have attorneys right now, how long can they actually sit in jail?
Our judges here try to get people attorneys fast. They don't want them just sitting in jail. Now, these defendants have a right to hire an attorney, you know, of their choosing. Sometimes it can take a defendant up to a month to do that. This judge wants to make sure these defendants have an attorney, you know, sooner rather than later. And so we're coming back in about a week and a half at the request of the defendants.
They still have no bond, right?
They still have no bond.
Understanding that at this point in time, only 2 people have been arrested in regards to Young Dolph's shooting. Do we know of any other arrests? Do we know we can move on right now?
All I can say is the investigation goes on.
Is Mr. Barnett, he was in Indiana in jail. He's charged as an accessory after the fact. Is he back in Memphis? Has he been extradited back?
My understanding is he's still in Indianapolis.
When is he going to be extradited? Do y'all know?
I don't know.
Any details?
Holiday season, but then last year, 365 days ago.
The question is, what is a proper statement? What does it entail? What are the details and what does it specifically protect? I don't think I can answer this. I don't think we can. Yeah. Because we didn't, none of that was, I mean, some of it was in the proof, but we didn't hear any of the evidence.
Cornelius talked about it, but I understand. We talked about it with his lawyers, that's got proper protections that you can't be charged. And he said, yeah.
Okay.
Could we just say it's a protected statement of police?
No. You can't say that. Even though it's kind of the truth. It is the truth, but no. I have to be very careful with I mean, that's almost putting evidence in without, you know, without it coming from the stand. I have to be very careful when I answer, when I define things and things like that.
And I guess we can't answer it.
Yeah, I can't answer it. So I will respond. The court can't answer these questions. I could go ahead and say that would be admitting evidence without a witness to do so, or I can just say I can't respond and be done.
Okay.
Yeah, they're not gonna like it, but they'll be all right. We can come off the record.
Court's back in recess.
his life was taken here. We got a chance to speak to Mia Jardine about how this last year has been without her life partner.
What does healing look like? What does true healing look like?
Those are questions that Mia Jardine says she's still asking herself nearing the 1-year anniversary of Young Dolph's death. In an exclusive interview with Fox 13, she says some days the healing process is hard.
My heart is so heavy. This isn't an easy time for me.
But she says this last year has given her time to test and trust her faith. In an Instagram live video on Thursday morning, she gave some insight on how that spiritual journey is going. And she says it's still a challenge.
I feel heavy, but I feel it from a lot of different ways and everything like that. And I'm feeling like being patient is the best thing that I can do.
But she says it's all about being able to rebound and push through, even when you may not necessarily feel like it or know what will happen.
Despite hurt, unknowing, lack of understanding, all of that, I'm showing up because I'm really trusting in on God. So I'm having a strong faith.
So what does happen now? Jardine says she's focused on taking care of her family and also turning her Black Men Deserve to Grow Old brand into a life mission.
That has been my saving grace because it's given my mind an occupation.
And she says as the investigation continues, she's leaving it up to the investigators and the justice system.
I don't have much to say about, any of that because I'm just waiting for all of the facts to come out. But I do believe and I know and I have faith in knowing that his justice will be served. And I know that without a shadow of a doubt.
Jardine adds that they were in the middle of planning their wedding when Dolph was killed.
That's Fox 13's Kayla Solomon reporting tonight. As many people are taking
to
time
honor
today
the late rapper, there are several community events happening today as part of Dolph Day. It's been organized by the Ida Mae Foundation, named after Dolph's grandmother. As part of this Dolph Day, a few members of Dolph's record label Paper Route Empire are holding events. Like Big Moochie Grape going to be at the Hickory Hill Community Center this morning for a turkey giveaway. Also
Hernandez
at
Govan.
11, Paper Route Woo and Snoop Bands will be at Christ Missionary Baptist Church on South Parkway for a give back event. And as we told you yesterday, Makita's Cookies is giving away Dolphin cookies to customers. There are many events going on for Dolph Day of Service today. You can find them on our website, fox13memphis.com. And coming up on Fox 13 News at
The man accused of planning the murder of young Dolph was in court. Hernandez Govan pleaded not guilty to all the charges against him, and that includes first-degree murder, conspiracy to commit murder, and more. Investigators say Govan is the person who put out a hit on young Dolph. They believe Govan started planning that murder too, for months before the actual murder.
Indictment alleges that Mr. Govan participated in a conspiracy to kill Adolph Thornton Dolph, and it alleges the dates of the conspiracy. That's about all I can say.
We entered a plea of not guilty today, and what that does is impose on the state the burden of.
Young Dolph and them pull it in.
Is that the vehicle that you?
Not necessarily. We was going back because we didn't know we were gonna get shot. Ain't nobody know we were gonna get shot.
You didn't plan on getting shot?
No ma'am. That wasn't part of the plan.
Had you not got shot, was there a plan in place?
We probably would have just took the car back, jumped in another car, went and burnt the car up, something like that. But we both got shot or whatever, and I was bleeding tremendously bad. We took the car back in front of Mr. Hernandez Govan, across the street from Mr. Hernandez Govan.
It has been nearly.
We jumped in the truck. We were trying to get cleaned up, so we were trying to find somewhere for us to go.
Who's he?
Justin.
Justin was trying
to find somewhere for us to go.
2 weeks since rapper Young Dolph was gunned down in Memphis, and today a private funeral was held in the Bluff City. Thank you for joining us. I'm April Thompson.
I'm Alex Coleman. WREG's newest team member, Bria Jones, from right here in the Mid-South, joins us.
Emotional day for the family of Young Dolph. We're told today a few hundred of his closest loved ones gathered here in Binghamton to say goodbye. Now take a look at your screen. This is a look at the procession leaving from First Baptist Broad Avenue Church earlier this afternoon. Pastor Keith Norman, who eulogized Dolph, spoke exclusively to WREG after the funeral. He says it took several days to plan the private celebration of life. Now, while he couldn't share who was on the guest list, he told us Dolph's grandmother, life partner, children, and other music artists were present. Now, as for the relationship to the church, Norman says Dolph's dad worked here. His girlfriend Mia was a member of the church, and his young son dedicated his life to Christ also at this church. Now, he says today was all about looking at Dolph's life and legacy.
His legacy was that a young black boy from Memphis, Tennessee can have a vision and he can make it. A young black man can take care of his family. He had 2 children who said, his son said, my father was the greatest man I've ever known. His daughter said, my daddy loved me.
He had FaceTime Big Juke, didn't know that, you know, that was like I work.
Y'all want your money then, right?
Yes, ma'am.
And let me ask you, did he promise to give you your money that day?
He told us he'd get with us when he got done with his kids or whatever, or when he got up, one or the other.
But you didn't have Juke's number?
No, ma'am.
So he couldn't get with you directly?
No, ma'am. He
Knew it
couldn't
far.
get with me directly.
So how would he have been able to get with you?
I would have had to go through Mr. Hernandez Govan or Justin Johnson.
All right, so
Interest in the killing of young Dolph is behind bars tonight. 26-year-old Devin Burns is in jail for aggravated assault and theft charges. WRG Shay Arthur is live at 201 Poplar with the very latest.
Police booked. This is the new mugshot for 26-year-old Devin Burns. He's in jail after police put out his picture, naming him as a person of interest in Memphis rapper Young Dolph's death. Burns also had outstanding warrants, accused of stealing a car back in June. Police say he shot at businesses in this Orange Mound strip mall last month. A woman told detectives she saw a man, now identified as Burns, pacing outside with a gun, making threats to kill people. As he left the shopping center, he shot at the building. 2 little girls, just 5 and 12 years old, were nearby. Thankfully, they weren't hit by the bullets. It's unclear where investigators finally arrested Burns and how he was tracked down, but he's not the only one police want to talk to about Young Dolph's murder. 26-year-old Joshua Taylor has also been named a person of interest. Also happening now, a search underway for Shango Barnett. He's looking at charges after detectives say he helped Justin Johnson, charged with murder in Young Dolph's death, hide from police. Barnett and Johnson were arrested in Indiana last month. Johnson is now back in Memphis, sitting in jail. But Barnett was released from custody in Indiana and hasn't been heard from since. A 5th man, Cornelius Smith, is also in jail tonight, also charged with the rapper's death. And again, Stephanie, Greg, we have asked police why these 2 men are being considered persons of interest. We have been told that all available information has been released. In the meantime, if you have information that could help detectives, call Crime Stoppers, 901-528.
what y'all gonna do after whoever y'all hit that day? You happen to hit Dolph.
Yes, ma'am.
Hit Dolph. You go back where? You go to the...
We go across the street from Mr. Hernandez Govan house. We swap vehicles. And now that's when I had went too fast. That's when Justin was trying to find somewhere for us to go. But he had FaceTime Juke first, and then let him know he was spelling out Dolph. And then
when you say he was spelling out Dolph,
like
was he going
jailhouse, D, you know, jailhouse spit.
In American Sign Language?
We still have a little bit of a crowd.
Okay, some more. Okay, some more.
He was telling them that was our work basically pretty much, and he like he'd get with us when he got up, and then he was trying to find somewhere for us to go so we could clean up or whatever because I was bleeding extremely bad, like I was really bleeding, and he had found somewhere for us to go, and that was in 2-line apartments. We went there to clean up or whatnot, and
Happened, and they're still trying to see what's going on. You can see now tow trucks are being brought in. Now we do know that we have heard that there are still some vehicles up there that may have been involved in this. I don't know Young Dolph's vehicle, it may still be up there, but we do have some tow trucks. We've seen 2 that have come through, and this one going through now, maybe actually getting ready to remove some of the vehicles that may have been involved in this. We have not gotten close enough to actually see any of those vehicles, and I know Jarita talked about what type of vehicles that Young Dolph had, and how he had bulletproof vehicles and that kind of thing, and not being sure what he was in at that time. But all of this obviously, apparently, happened inside the store when he was outside of the vehicle, possibly. This is what we're hearing, that talk that's going around now. But they're moving in with the tow trucks to move some of the vehicles out. Police now going in beyond the barricade, but it really has quieted down here a lot with the citizens that are just standing around, but still some, but not as many as it was before when this initially happened.
All right, thank you, April. April, I have a question for you. Does it appear that any active search is going on in that area? I know you said police haven't been telling you much, but does it look like they're searching for anyone?
We can't tell whether they're searching for anyone or not, but we know they're talking to a lot of people. Now, we have seen a lot of police officers in uniform talking to people, and as you know, Stephanie and Alex, there are probably tons of undercover plainclothes police officers that are out here now and getting out in the community, talking to people who knew him, talking to people that may have known any kind of beefs that may have existed between him and anybody else. So I'm sure
we have a verdict. To the members of the public, if you don't think you're going to be able to not show any emotion during the reading of this verdict, I ask you to remove yourself now. There won't be, the court won't tolerate any outbursts of any sort from anyone. You wanna bring me here?
Ready, Your Honor?
Yes.
The jury's now into the courtroom.
Ladies and gentlemen of the jury, have you reached a verdict? We have, Your Honor. Four person. If you would stand and read your verdict, please.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Thank you. Juror number 1, is that your verdict? Juror number 34, is that your verdict? Yes. Juror number 35, is that your verdict?
Yes.
Juror number 11, is that your verdict? Yes. Juror number 14, is that your verdict?
Yes, ma'am.
Juror number 17, is that your verdict?
Yes, ma'am.
Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict?
Yes.
Juror number 25, is that your verdict?
Yes.
Juror number 44, is that your verdict?
Yes.
Juror number 23, is that your verdict?
Yes, ma'am.
Juror number 28, is that your verdict?
Yes, ma'am.
Thank you. Ladies and gentlemen, I want to thank you again for your time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you've made. Thanks again for your time and attention. You are excused.
Jurors excused.
So you guys dropped off.
Jumped in the edge on the video. You saw I was driving edge in them car.
I'm not talking about the apartments. Remember when you dropped off the car? Let's focus. When you guys dropped off the white stolen Mercedes,
Right.
you said across the street from Mr. Govan's house.
Right.
You and Justin got out of the car.
I got out I got out the car to move the truck. You had to move the truck out the yard first to pull the car up. That's what I'm saying.
Okay, so you did that.
Yeah.
Whose truck was it?
It was Justin, I guess.
All right. Who drove the truck away over to Tulane Apartments?
I did.
So that white SUV that we saw you were driving it?
Yeah, that was me.
Okay. You don't know who struck that?
No.
All right.
It was Justin, I guess.
All right. When you drove the Mercedes into the driveway.
No, I did not. I can't drive too good. I jumped out the Mercedes to move the white truck. But Justin parked the Mercedes. He was driving, as you saw in the video.
All right. So even though you couldn't drive too good, you drove the SUV to Tulane
I
Apartments.
said I couldn't drive too good.
You just did say that.
I said I can't drive 2 vehicles, 2 cars.
Okay.
At one time.
All right. So did Justin have the keys to the Mercedes?
Yes.
Okay. So he does whatever with the Mercedes, takes the keys, you guys get into the SUV, you drive it away to Tulane Apartments, right?
Yeah.
Okay. I want to get into the AutoZone. I know you don't remember, but the car was found on the morning of December 20th, 2021, which is about 3 days after the shooting, okay?
December the 20th?
I'm sorry, November the 20th, 2021.
Oh.
We will work with that, right? You're now saying that the night before, which would be around midnight, I think you said, of the 19th, Mr. Govan gave you some money for car cover?
Yes, sir.
All right, and you said around midnight or so he did that, right?
Yeah, in between that time.
Okay.
Many hours.
All right. You mentioned at one point that he paid you with Cash App, and then at one point you mentioned he
I
paid
ain't
you
say
with
nothing
cash.
about cash.
So these jurors didn't hear the word Cash App come out of your mouth at
I
all?
said he paid me with cash.
Okay.
He gave me cash to go get the car covered.
Did he ever pay you any dollars with Cash App?
No.
Okay. So he gave you cash to get, did you go get the car cover?
Yeah, I went and got it, but I didn't go inside the store myself.
Okay. So now let's go back. So you're telling me when this happened, on the night of the 19th, you were with your girlfriend?
Yeah.
Angela?
Yeah.
Okay, because you didn't mention that when they were asking you the question. So let me get this straight.
What you saying?
On the 19th, the night before the car was discovered, you cleaned that car, right?
Yeah.
Angela was with you when you were cleaning the car?
She wasn't with me, she dropped me off.
All right, where did she go?
I told her buzz a block, right around. So I called and told her to come back.
All right.
She wasn't with me.
So you said you called Mr. Govan to tell him that you were going to clean the car so he wouldn't shoot you, right?
Yeah.
So did he come out to visit with you?
No, he didn't come out.
Then how did he give you the money that night to go get a car cover?
I went back over there. I ain't say it might have been that same day now. I said it might have been the next day, but I went over there, get some pills. Or it might have been later on, because I went over there to get some pills or whatever, to stay up, some extra pills, once again.
Right,
And
but
he
you understand,
gave me the money to get the car covered.
you understand, we're running a little bit out of time because you told us under oath that he paid you on the 19th of December of 2021 in the evening hours around midnight.
Then I said it might not have been that day. It might have been the next day. You know, it might have been like I probably had the days mixed up. Like the day before, I probably went and wiped the car. Then on the 19th, he gave me the money for the car cover.
Well, see, there's a little problem with that. The car was found on the 20th that morning.
Okay.
So if you wiped the car down the night before it was found, that would be the 19th. You'd agree with me, right?
Exactly.
And if he also paid you at the same time, that would be the 19th, right?
Yeah.
Okay, so if you
But the time, like the time of what time, like exactly what time this took place, what I can't remember it.
But it was all at night.
Yeah, like midnight, early morning.
Okay, and you went to the AutoZone to buy that night, and you just...
Nah, I ain't go that night. I went that morning to get that car cover, because I wasn't finna put it up. The AutoZone ain't no 24-hour AutoZone where we get no way.
Okay, what time did you go to the AutoZone?
Soon as they open up, early in the morning.
So like 7 in the morning.
Can't tell you exactly what time.
Okay.
I finna see her live.
Who'd you go with?
Me and Angela.
All right, so now you've got Angela involved in covering up the murder, like hiding evidence, right? She's helping you get this?
No, I ain't ever involved with doing nothing. She won't hide nothing. She wasn't doing it. Nope, not finna lie like that.
All right, so when she picked you up at 2 Lane Apartments, what happened to your clothes?
What happened to my clothes?
Yeah, the bloody clothes.
We had changed down at 2 Lane Apartments.
Where'd you get the clothes?
We got them 2 Lane Apartments.
Like from who?
Whoever that was. I don't know that good.
So they just had something to fit your size to wear those clothes?
Yeah, you see, when we went in and we came out, you see, before Angela pulled up, we had on different clothes when we came out.
Okay.
You see that on the video.
So you remember that part, right?
Yeah.
Okay. You went to the AutoZone. You ever been to an AutoZone yourself before?
Yeah, I had cars.
Security cameras everywhere, right? At the AutoZone?
I don't know about all that.
All right. Would it be out of the ordinary? You've gone auto part shopping before. You just said you've been there before, right?
Right.
All right. Do most businesses that you frequent have surveillance cameras?
Of course.
All right. So your car, what car was it that went to the AutoZone that morning?
The SUV that picked me up.
So Angela's car.
Yes, sir.
So if I was to call AutoZone to get surveillance, I could easily see the car coming and going.
Yes, sir.
All right, and if I went inside, I could easily be seen on the surveillance cameras because, you know, they have it for shoplifting and all that. Angela would be front and center, right?
I ain't gonna say front and center, but I told her to go get the car cover.
All right. And
go
so,
get a car cover, universal car cover.
all right, and so if it's around 7 in the morning, she used cash to buy it. You get a receipt even if you use cash, right?
Right.
Okay. So if I wanted to double check, say I'm a really good detective and I want to figure out what's happened, I could easily go to AutoZone, pull the footage, ask them for just their receipts from between 7 and 8 that morning, who bought a car cover. I could very easily validate what you're saying, right?
Of course.
Okay. We agree on that. Thank you. With regards to Mr. Govan, you talk to him almost every single day, right?
What you mean?
Like you would hang out at his house?
Yeah, I go through there, grab a few, pull up on him.
Yeah, I mean, you talk to him pretty regularly, right?
Right.
So if you say, hey, he called me or he did this, you could have communicated with him for any reason. You have to take your word for what it is that you guys talked about, right?
When you talking about?
Well, I mean, you're a little vague on the date, so I'm just asking you, if you met him that summer.
I'm a little big on the date.
A little fuzzy on the date.
Oh, yeah. I've been locked up almost 4 years.
Right, but you've also talked to the police over those course of the 4 years, especially in the first 6 months.
But not like this, not like...
Right, I know, because there's pressure here when you're under oath, but I'm saying, and you've also
It
talked
ain't no
to...
pressure, because I'm telling the truth. Ain't no pressure. I'm being real.
Your truth is your truth, I understand. You've talked to these people about 9 times, essentially, the government lawyers, right, prior to testifying here today.
I can't tell you exactly how many times I talked to them, sir.
Okay. You mentioned during your testimony that you actually never communicated with Jook, is that right?
No, I never communicated. Well, I did, to be honest with you. I forget I had, like, after they found the car or whatever, and, man, I wasn't talking to Justin or him. So I had inboxed him on one. Well, I forgot what it was, and I'm like, man, I'm Govan homeboy, man. I need to holler at you, go. I'm trying to get my money. You know what I'm saying?
So who were you communicating with?
I was inboxing Juke, like, man, this Govan, little homeboy. Like, really, I ain't want to say this who Govan hired, you know what I'm saying, to handle the bid. I'm like, this Govan homeboy, I need to get up with you, because I'm trying to get my bread.
All right, so when you said inbox, is that an email?
I forgot what I had. Hit the man up on. I forgot what it was.
Okay. And the reason I ask is you didn't want to give up anything or do anything, but earlier, when you first met Jook, you said Mr. Govan introduced you as Little C, the guy done the shooting of Wu, so we already knew you were a shooter. So why would we need all the cloak and dagger if you're trying to reach out to Jook?
Nah, because look, this had went, man. After the shooting or whatever, after they discovered the car or whatever, Justin had got with me and was like, man, look, man, Juke saying that he'll get with us on his own terms or whatever, and don't trust Govan or nothing like that right now. You know what I'm saying? He was like, so in my eyes, there was so many crosses. You know what I'm saying? Like Justin had ran out with the cake or whatever, and I couldn't trust him. I couldn't trust nobody. You know what I'm saying? So I was like, man, I'm gonna take initiative on my own, and he Juke up on his little, I forgot it was Instagram or something. You know what I'm saying? And I was like, man, this Govan homeboy. You know what I'm saying? Like,
Sure.
get up with you. Really, I need my money.
Did you ever text Mr. Juke at all during the course of all this?
That's what I was saying on a website, like on Instagram or Facebook, something like that. I forgot what it was. I ain't have his number personally. I could not contact him, like call his phone and say, Juke, where my money? No, I couldn't do that.
Okay. Could Angela do that?
No.
So nobody...
Angela ain't know nothing about no Juke or none of these. Like, no, she couldn't just hit Juke up. She don't know him or Govan.
Can I just have this 1 second, Your Honor? About parking the car across from Govan. We've talked a lot about parking the car across from Govan's house, but you recall some hours ago you said your friend Bobby Carter lives across the street from Govan as well, right?
He stayed like across up the street, like close towards the corner with his mom.
All right.
And they called each other brothers. Him
Okay.
and Govan.
So your testimony to me now is when you told them whatever about Bobby Carter, that he didn't remember how they will. Now you're saying Bobby Carter lives up the street.
He stayed across the street, but houses down from where they caught was.
How many houses?
I can't remember, about 3, 4 houses, close to what that is?
Bradley?
Nah, close. Bradley is the street they stay on. Close towards what's the Crossway Street?
I'm not from Memphis, I don't know.
It's been a long time. I ain't been out there. I can't tell you.
The reason I ask is you also mentioned you just lived a couple minutes from Mr. Govan's house, right?
Yeah.
Okay. So you live a couple minutes from Mr. Govan's house. Bobby lives across the street, some 3 houses down. And you and Bobby did the first shooting of Wu when you guys had a shootout with Mr. Wu. Is that correct?
Yeah, me, Bobby, Justin, and we got Mr. Govan gave me his gun.
Okay.
Gun.
So now Govan gave you the gun. I understand that. Was Treon Ingram also there for that shooting?
The absence of evidence is not the evidence of absence.
What?
Still waiting on the jury verdict deliberations. To deliberate. I had to pause it real quick because my frames was dropping, but we be back in there. Appreciate y'all, family. Shout out to the stream sponsors.
I don't know none of them folks. I don't know none of them.
How many people were there all together at the first shooting of Wu?
At the shooting?
At the shooting.
At the house at Mr. Govan's house.
Okay, let's try this again. You went with Bobby Carter and you said Justin was already there.
We all met up at Mr. Govan's house. And me and Bobby jumped in one vehicle, and Justin and another guy was in another vehicle.
All right. So when they asked you before, now there's a 4th guy that was going to do the shooting with you guys, right? It's you, Justin, Bobby, and a 4th person you don't know.
Right.
Okay. So you guys drove off and found Wu and had a shootout.
Yeah, he had told us Wu was at the house, Mr. Govan.
So Mr. Govan knew exactly where Wu was at the date and the time.
Where Wu stayed at.
Okay, so did you shoot up his house?
Nah, like I said, the gun had jammed up. I was on foot walking up, and he was coming out the house. And the gun Mr. Govan had gave me had jammed up. And I had to jump behind the tree, and Bobby was trying to get to me.
Okay. Were you ever charged with the attempted murder of Wu?
No.
By the state?
No.
But you told them that you tried to kill somebody and the gun jammed up, but they didn't charge you with a conspiracy or attempted murder or anything?
I don't know police then. Like, it was street stuff. Ain't nobody attempt, like, he shot back. Like, it was a shootout. After that, it was unity.
Well, like with Mr. Dolph, though, that was a shootout too, because they shot back at you and they hit you twice.
We shot first, though. We shot first, so it really wasn't. We ran as they were shooting back. We were pulling off as he was shooting back.
Okay. In your statement to the police in March of 2022 and Mr. Hagerman, do you remember telling them that two masked men met you prior to your arrest and gave you $50,000 in cash inside a brown paper bag?
No, I ain't tell them nothing like that.
All right. Did you tell them about... Okay, you didn't tell them. Got it. At some point, money showed up for your lawyer after you got arrested, is that right?
Yeah.
All right. And then you were talking to the police and they asked you what did the money mean, and you said it was understood that you were on Jook's team, is that correct?
No, I ain't say nothing like that.
You sure? Because I got it on video, so I'm just going to ask you again. Yeah, they said, is it understood what you were going to be doing, that they paid for your lawyer?
Nah, I wanted my money. The hit already been done.
You're in prison, and $38,000 or $50,000 or whatever just shows up to pay your lawyer, is that correct?
Yeah, the money came.
All right, and that came from Mr. Jook's CMG?
I don't know who it came from.
So it just magically appeared?
I don't know who it came from. Like I said, I couldn't call nobody. I don't know who it came from.
Do you remember talking to the police on August 10th of 2022?
Probably did. What was said?
Well, I'm going to show you what was said, and we're going to go through it. May I approach the witnesses?
You can give him the...
I want you to read paragraph 17 to yourself, and I'm going to have a handful of questions.
And you're all right. Can we approach, if you might have them put that down, please? Hold on for
He did car wash before. And then I went the day of the shooting and I met Mr. Govan up there.
All right, so is it your testimony now, after I just asked you, you've been there before and you know what it looks like? You've only been there twice. Is that your testimony?
I can't tell you how many times I've been to get a car wash, sir.
Okay. You live in the same neighborhood as Mr. Govan, just a couple minutes away.
Yes, sir.
The pressure room is just a couple minutes away from both you guys.
Yes, sir.
And you know what it looks like.
Yes, sir.
And you've been there.
Yes, sir.
Have you been there without Mr. Govan?
No, sir.
Okay, so is it fair to say then you're saying you've only been there twice in your life?
I can't tell you because I've probably been there 2-3 times with him. I don't know. I just can't tell you, sir.
Okay, so it was, I went there to get my car, he got his car washed.
I asked him to answer.
Why don't they, well, I'm sorry, Your Honor, I apologize. You went there one time with Mr. Govan so he could wash his car.
Get his car washed.
Okay. And then the next time you mentioned it was to pick up your phone.
If you want to say that, yes, sir. I went back to pick my phone up from him at the car wash. He told me to meet him where he get his car washed because I already knew. So, you know, I went there and met him.
And then there may have been other times you went to the car wash with Mr. Govan.
No, I'm not saying all that, sir.
Okay.
I'm not saying that.
When you go to pressure wolf, you do notice there's cameras all around the building and there's only one way in and out.
I don't notice all that, but it might be.
Okay. So if I'm a good detective and you say I went to pressure wolf, certainly they would have gone to pressure wolf, seen the cameras and asked for the surveillance footage, right? To back up
what they did, sir. I can't do their job for, I don't know. I can't tell them. I don't know what they did, sir.
All right.
What up, Aaron, adventuring, Kiki the Conqueror. I see y'all. Appreciate
When
you
you
joining.
talked
family.
about when the meeting happened, was it just you and Jook when the meeting happened?
No, me, Jook, and Mr. Hernandez Govan, sir.
And was that planned in advance?
Nah, I told you I was just pulling up the pills. Actually, Jook was already over there. And Govan was like, we're going to let's see right here. You know what I'm saying? This is what we had to be the other day. And
All right.
Jook like, hold on, put them phones, you know what I'm saying? Can't trust you like that.
With regards to trying to figure out when this meeting happened with Jook, that's the first time you saw him, right?
Yeah.
Okay.
First time I saw him.
And you just know Mr. Govan for a very short period of time prior to this meeting, right?
Right.
Okay, but Govan, even though you don't even know him, approached you and said, you want to kill some people.
Nah, he said, you know, paper I got hits on the head. Not you want to kill some people. Then paper I got hits on the head. The boundaries on it.
Right, so...
This our turn.
Okay.
You know what I'm saying? Street.
He
This our
just-
turn. I always seen.
So is he doing a public service announcement saying, hey, there's a bounty on these people, or is he telling you to do it?
Like that. You don't do shit like that. You know what I'm saying? You first you gotta figure a person out. So that's basically what he was doing, figuring me out. He saw I was buying pills for him. So I probably need a little money because I get pills on credit or whatever for him. You know what I'm saying? And he saw me and Bobby tight, so he figured me out and was like, you know, you wanna make some money?
Okay. And so this is a murder Mr. Govan couldn't do himself to make $100,000. He needed you to do it and maybe get $10,000 out of it.
I don't know what he could have did himself, but I don't know. I can't tell you all this, sir. He probably, well, he had a whole bunch of young guys around him, you know what I'm saying? So I guess he wanted to just send us on out, you know.
So now he had a whole bunch of guys that he was talking to this about.
Nah, I'm saying he had young guys around him, you know, we'll come around him, so, you know.
So is everybody supposed to be told, go out and kill people and make some money?
I don't know, sir. I don't know about all that. I'm not finna sit here and lie, sir.
Okay, but now you're telling me that he had other young people out here and everybody knew that there was a price on
I didn't
Godz.
say everybody. I don't know who I knew, sir, but I know me, Bobby, Justin, and the other guy. I don't know who I knew because I'm not with their little crew. So what they talked about when I went around, I don't know, sir. You know what I'm saying? I was Bobby's partner. I wasn't his partner really, but you know, once me and Bobby, he saw me and Bobby was, then he, you know, started, you know, trying to play a bundle.
All right. So a gentleman that you've just recently met decides he's going to trust you enough to tell you that there's a price on people's head. And just like that, you trust some guy living in Orange Mound to be able to come through with the money based on his representation.
Nah, it wasn't any representation. It's just, you know, when you hungry for some money, you would get out there and get your hand dirty, you know what I'm saying? And then, like I said, I had already saw Juke, like after he told us, and we went on one mission, and Bobby clarified that, you know, his brother good for, and Juke was over there when I met, and Juke clarified that our money was gonna be good. It's go time.
Right, but remember...
We done been to the club together and everything.
I get it, but
And Juke was at the club too.
Right, I understand Joe told you the money was good, but the problem with that statement is you'd already shot at Mr. Wu, you said close to a month or so before meeting
Nah,
with
I
Joe.
didn't say no month or so before meeting no Joe. I didn't say that. It was a couple days later. When I pulled up and got them pills, it probably was the next day or 2-3 days later. I can't remember the timeline, but it wasn't no couple months.
So when you said 2 weeks, maybe a month,
Nah,
that was incorrect.
I didn't say that, sir. I didn't say that. It was like probably the next day I pulled up over there, bought some pills from him, the next day or two. I don't know exactly when. And he was like, here go, let's see right here. This who put that work in, who shot it, Woo.
All right, so if all this is already known and understood, why would Mr. Jook need you to take your phones out and then walk you through how much everybody's worth? You already knew all that
If you want me to be honest with you, I can be honest with you. Because they were saying that Mr. Govan was like one straight or nothing like that, was like an informant and stuff like that. And, you know, they were saying that he was police, so
Okay.
that's why all the phone gotta go outside, you know, when you talk around.
So let me back this up. You were told at the meeting that Mr. Govan could be police.
Nah, Bobby been told me that.
So Bobby told you.
And then the streets talk, you know, people in the neighborhoods were saying that, you know, he had got him popped and he had got him sent to jail and he was setting them up and stuff like that.
So let's maybe go back to scratch. You just met this guy for a short period of time over the summer. Bobby's already told you he's a snitch, maybe works for the feds.
But you can't tell me nothing about nobody like that. If he ain't did no wrong to me, he ain't did no police stuff to me, he ain't police me, so I don't just take the streets say that about anybody, you know what I'm saying? They
Your
probably
friend-
saying it about me right now.
Your friend Bobby Carter told you that. Your friend.
An associate.
Okay.
I don't have friends, I have associates.
All right. Your associate told you that this man that you just met is a federal snitch. You can't trust him, right?
Yeah, but people say that about anybody, man, you know what I'm saying? So, no, you ain't did no police stuff to me, like, I ain't got no bad to say.
We're going to find and sentence Mr. Johnson on the conspiracy to commit first-degree murder. 35 years.
So we played the other piece of the second time he got sentenced because it was two different charges. But this is the first one. I don't think we played this one yet. Appreciate y'all being here. Hit the like, hit the subscribe, tap in. Let's go.
That's a range 2 offender. As to the convicted felon in possession of a firearm, I'm going to sentence him to 15 years. As a range 2 offender. State has asked this court to run these sentences consecutively. They've asked me to find that the defendant is an offender whose record of criminal activity is extensive. They've also asked me to find that he is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime in which the risk to human life is high. The court also has to find that. Mr. Ward, you have a motion?
Yes, Your Honor.
Circumstances around this offense are aggravated. That confinement for an extended period of time is necessary to protect society from the defendant's unwillingness to lead a productive life and the defendant's resort to criminal activity in furtherance of an anti-societal lifestyle. And the aggregate length of the sentences reasonably relate to the offense of which the defendant stands convicted. The state argues as to the the defender having a record of criminal activity that is extensive, that the court can consider not just his prior history, which the court's already talked about, the 3 prior aggravated robberies, 3 prior aggravated assaults in the federal firearms case, but also this first-degree murder, conspiracy to commit first-degree murder, and convicted felon in possession of handgun. It's unfortunate that we've witnessed Mr. Johnson's progression in violent activity. He's had these prior convictions which dealt with firearms, which dealt with violence, and the lack of regard for human life. And it didn't get any better, it got worse. A whole lot worse. The state also argues as to the dangerous offender that the defendant was not motivated because of fear or hate. That this was greed and money and fame. This was just a hit, a way for him to further his career. The defense argues that practically at no other time above the life sentence that he's already been sentenced to will protect the community. The defense argues that the life sentence will make Mr. Johnson eligible for parole somewhere around 70 or in his mid-70s. And there's no need to protect the community any further because of that life sentence.
Yeah, I think that is mostly the same one. She just gonna say life and consecutive, but this one we haven't watched for sure.
Was moving for a directed verdict, understanding that Mr. Cornelius has given some statements about that he was ordered to do it. I don't know if that rises to the level of a conspiracy or agreement amongst the parties. It was very inconsistent as far as that goes. Secondly, there's been no mention about Justin.
My bad, I thought that was from the last trial. That's from this trial, but we can watch it though real quick. Let me see, what is the... Actually, I'll come back to that. My bad.
Your friend Bobby Carter told you that. Your friend
Associate.
Okay.
I don't have friends, I have associates.
Your associate told you this man that you just met is a federal snitch. You can't trust him, right?
Yeah, well, people say they better get ready, man. You know what I'm saying? So, no, you ain't need no police stuff with me. Like, I ain't got no bad to say about you. You know what I'm saying? Cool with me. So, no streets talk like that all the time. Associates or whatever. But it needs to be quiet for me.
Sure, they're out doing that. And that individual that I talked to and said they were meeting with the higher ups, they're probably saying the same thing, that they're out trying to talk to people because, as we said, somebody knows what happened. Somebody knows that this was going to happen, and somebody knows where the people who did this are right now. So what they're trying to do is to get out in the streets and talk to people and get people to open up. A lot of times when things happen, and we know it in our community, when crime happens, people don't want to say anything. They want to be quiet. They don't want to get involved. And they're hoping, because of who Young Dolph was, that might prompt some people to finally say something, saying enough is enough. I know something. I'm going to, say what I know. And that's what it's going to take to help police to kind of solve this, too. That's why they say the community involvement is so important, because the people are the eyes on the streets, and they know anything that's going on, and they know when it's happened, and they know what happens afterwards. And that's what they're going to kind of depend on as well to be able to get this solved, Stephanie.
These were crimes that were committed in our community in the middle of the day, in broad daylight, other people around, for greed. Greed, money, and fame. I'm going to run count 1 and count 3 concurrently. For consent to the license.
Mama house and everything. Why this shit going on right now? This shit going on right now. Damn. It's like grandma. This is grandma. Grandma got hit. I know this house, but you also going on. They went to God's house too. God's mama house. I just got the information. Yup. They got the information. They just shot a private. Oh, they got the big man at private. He's been right now. Right now.
She had the family, so he ain't gay.
Yeah, she fought on. Right now. That's why you ain't over it. They just killed that man grandma.
Killed dog grandma?
Yeah. That one on. These motherfuckers mine. That could be on this big old pump, man. They finna get in that.
Long
live dog.
That's that big dog.
Go.
Topping your news leader at 4 today.
That nigga died about 10 at night when I said I ain't moving bodies and I like found him.
Detectives to actually get inside that courtroom. And the prosecution and the defense, they've been telling some very different stories about who is to blame here in the rapper's death. Justin Johnson, one of the men accused of shooting Young Dolph outside a Memphis cookie shop, sat stoic in court. Shelby County prosecutor Paul Hagerman painted the picture of the day of the crime for the jury, who was brought in from out of Shelby County. Hagerman says Johnson, an aspiring rapper known as Straight Drop, shot Dolph along with a second man, Cornelius Smith. He says the shooting comes after a $100,000 hit was ordered by Big Jook, who was high up at CMG, a rival record label and the older brother of rapper Yo Gotti. The contract hit was arranged by a third man, Hernandez Govan. Investigators say Govan would seek out new talent for CMG and also provided drugs to Smith. The jury was shown the moments Young Dolph was killed outside Makita's Cookies. Hagerman said to Johnson and Smith, the shooting comes after a $100,000 hit was ordered by Big Jook, who was high up at CMG, a rival record label and the older brother of rapper Yo Gotti. The contract hit was arranged by a third man, Hernandez Govan. Investigators say Govan would seek out new talent for CMG.
That's crazy right there, because then if they convict him right here and they find him guilty of this, then that means that the doors is open for them to go after who name they just say?
Straight Drop shot Dolph along with a second man, Cornelius Smith. He says the shooting comes after a $100,000 hit was ordered by Big Jook, who was high up at CMG, a rival record label and the older brother of rapper Yo Gotti. The contract hit was arranged by a third man, Hernandez Govan. Investigators say Govan would seek out new talent for CMG and also provided drugs to Smith. The jury was shown the moments Young Dolph was killed outside Makita's Cookies. Hagerman said to Johnson and Smith, the shooting was, quote, just business.
What we watched up here is so quick, and we watch it and we call it violence. In the yellow, riddled with bullets, dead. We watch that and we call it violence. For Cornelius Smith and for Justin Johnson, it was just business.
But Johnson's attorney says his client is innocent, saying there's two sides to every story, and Govan was using Johnson.
You like to exploit. They like to exploit young rappers, like Mr. Johnson. He brings no skill to the table, but you're going to hear testimony about how he intended. It was his sole mission to get a 30 to 60% piece of Mr. Johnson.
Shelby County District Attorney Steve Mulroy was also present, speaking to us about the trial finally happening nearly 3 years.
A local artist and a look back at incidents involving Young Dolph. Jordan?
Candles and balloons line the pavement outside of Makita's Butter Cookies.
We can't continue to go through this.
The rap community is calling for gun violence to end after Young Dolph was gunned down Wednesday evening. Tom Ski Mask, a Memphis rapper, wants Dolph's death to be a catalyst for change.
I watched a young brother come from nothing and be successful, and I couldn't do nothing but respect that. Now, let's respect him and change this.
Back in 2017, Young Dolph's vehicle was shot up. He was also injured in a shooting later that year in California. In the past 2 weeks, Soulja Boy and Young Dolph exchanged words on social media, their disagreement appearing to be over which artist was better. As MPD searches for those responsible for Dolph's death, Ski Mask wants to see everyone put their differences aside for the sake of the community.
We got to change this. If it don't stop, it's going to continue. With me, it got to stop. I got children. I got a grandchild. I don't even want my grandchild to grow up in this city now. That hurts.
This week, the longtime Memphis artist is planning on hosting a forum for Mid-South rappers to come together to discuss ways to end ongoing feuds among artists.
If we can't stand together and show unity, it's never going to happen. And I need everybody to stand together with us and let's unify this.
The forum is scheduled.
On November 17, 2021, our lives changed forever. A son, a father, a brother, a friend, a businessman, a music artist, a philanthropist, and life partner are all among just some of the titles that my brother Adolph Robert Thornton Jr. held. Titles that have now left a missing piece in the lives of so many. I want to say thank you to the jury for their service and decision in this case to bring us one step closer to justice for our family, friends, supporters, and the community that has supported us during this time. Thank you to Judge Mitchell, Shelby County District Attorney's Office, including Paul Hengerman and his team, the MPD, U.S. Marshals, Tennessee Bureau of Investigations, and other investigators and staff that assisted us with this investigation and case, ensuring that those responsible for this crime and involved with this crime have and will be brought to justice for their actions. We realize this act of violence has impacted so many outside of our family and friends. Your outpouring of love and support throughout this process does not go unnoticed. We ask that instead of focusing on those who committed this crime, you focus on the man that Adolph Robert Thornton was. Regardless of the name that you may know him as, such as Adolph, Dolph, or Young Dolph, we ask you to remember the man who enjoyed being a father and spending time with his family. We ask that you remember the man who enjoyed giving opportunities to those who are often overlooked and counted out. We ask that you remember the man who enjoyed giving back to others and being an inspiration to those who come from less than ideal backgrounds, and knowing that they are seen and can change their outcomes and the lives of others by doing something positive. We will continue to heal and keep Adolph's legacy alive. We ask that the public and the media continue to keep our family in their prayers, as well as continue to respect our privacy during this time and the next steps of the judicial process as justice is served for all those involved, for our loved ones. Thank you.
Manager of Makita's Cookies and the daughter of Pamela and Maurice Hill. Tonight, in her own words, she tells me what happened that day and how her family has been grieving the loss of young Dolph.
I freaked when I found out. I couldn't even drive, so please believe it hit us in a way that you guys couldn't even imagine. Because like I said, he was considered a brother. That man did not deserve that. He was just in there to buy cookies for his family. And it's terrible that we can't even step outside of our house and feel comfortable in the neighborhood that he knew and loved. 6. And supported. But it has been a challenge. We have had a couple of sleepless nights since this happened. So we just want the city to know that we are so sorry that you guys had to endure this and see this.
And just days before the shooting, the store posted social media that young Dolph made a point to stop by on a regular basis. The mom and pop shop has been around for 20 years and opened their second location downtown a few years ago. But Dolph stopped at this one, another symbol of his dedication to the community.
That man did not deserve that. He was just in there to buy cookies for his family. And it's terrible that we can't even step outside of our house and feel comfortable in the neighborhood that he knew and loved and supported. Please pray for his family, because that's just that's unreal to me. I can't even imagine what they're going through. We just got support from Young Dolph's wife. You know, she supported us, so we appreciate that. She's backing us, saying that, you know, he enjoyed the cookies. He was there to pick up cookies for us all the time. So please back them up, support them. And we do appreciate the support of the city, because they have been extremely supportive. A lot of people have been praying for us. They've been reaching out to us. They've been telling us that, you know, we got you guys back. You know, it's a senseless tragedy. We want the violence to stop. And whatever we got to do to get behind the city to get this to stop, we're going to do that. We need to. So we want the city to know, we want the public to know, let's just create a lot of peace, man.
Create a lot of peace, she says. A number of people have been reaching out and offering support and well wishes to Makita's Cookies, including Hollywood director Prentice Penny, who visited the city for the Memphis-based movie Uncorked. He said, quote, I hate hearing about Young Dolph. It's so
They were able to do
unnecessary and
that,
tragic.
not guilty on 7 counts for Tadarius Bean, Justin Smith, and Demetrius Haley tonight. April Thompson, WRAG News Channel 3.
All right, thank you, April. Well, just a short time ago, Memphis Mayor Paul Young and Police Chief C.J. Davis released a joint statement on today's verdict. Here's what they had to say.
This message is for our community. Today, my prayers are with the Nichols family and our entire city. I understand the pain we're feeling as a life was lost at the hands of officers whose actions don't reflect the values of our Memphis Police Department. Memphis is still healing, and that healing demands that we work together. As a city, we're committed to doing the work of creating a deeper trust between law enforcement and the people of Memphis. And on behalf of the city, we're steadfast in our dedication to creating a safer, more just Memphis for everyone.
Today, a verdict was reached in the trial concerning the death of Tyree Nichols, and that has had a profound impact on his family, our department and city, and the entire nation. Policing in Memphis must always be ever evolving and continuously improving, and I am confident that our team is ready to further the work of creating ongoing change. As I have stated before, we believe in improved policing, in training, and in progress we are seeing daily. We recognize the pain and grief this incident has caused, and the men and women of the Memphis Police Department remain committed to rebuilding trust and working together toward a stronger, safer Memphis for all.
In the
5 days after the shooting death, rapper Young Dolph inside of a cookie shop. Makita's is reopening its downtown location. Thank you for joining us this afternoon, everyone. I'm Alex Coleman.
And I'm
For the first time in 5 days, Makita's downtown location is back open. The smell of freshly baked butter cookies fills every inch of the shop.
And that was one thing that Dolph did used to say when he get out that expressway. He was like, I can smell y'all like getting out the expressway, man. I had to come in. So, man, to know that we're not going to see that face anymore is... I'm trying to hold back tears now. Yeah, I'm sorry.
Both Makita's locations were closed after Memphis rapper Young Dolph was shot and killed while inside the shop on Airways last Wednesday. Since Dolph's murder, operations manager Raven Winton says they have received support from across the country, including from Dolph's partner, Mia J.
We couldn't even imagine what she's going through right now with the kids and everything.
These are amazing people who make amazing cookies, and we just want to make sure that that continues on.
Winton says the Airways location will remain closed through the end of the year. She says they're still trying to determine what's next for the shop, but she says they plan on keeping Dolph's name alive.
We know that the city is in mourning, and we don't want to stop that.
Winton says Dolph's favorite cookie was their chocolate chip. And she says as a way to remember the rapper, who she says was one of their very loyal customers, they plan on renaming the cookie after him. Reporting from...
The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within the offense are the lesser included offenses: facilitation to wit, conspiracy to commit first-degree murder. The second count of the indictment charges the offense of first-degree murder. Embraced and included within the offense are the lesser included offenses of second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. The third count of the indictment charges the offense convicted felon in possession of a firearm. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of this conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures, other than silence, for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere presence is not sufficient to support a conviction. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the conspiracy, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances, or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable in count 2 in this indictment. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence.
The absence of evidence is not the evidence of absence.
What?
Well, family. Look like they closed out for the day. So the verdict probably won't be read until tomorrow. They'll wake up and do deliberations. But I got my stream set up, so after this ends, it will redirect you to that one if you want to hit the like and set your notifications so it will let you know as soon as I go live. Appreciate y'all, family, once again. Shout out to everybody in the chat. Appreciate y'all joining. Shout out to all y'all, family. Let me see who up in here. Oh, my eye. What happened to my eye? Shout out to Tia C. Appreciate you, family. Brown Sugar Babe. Appreciate you. Aaron Adventuring. Appreciate you. Kiki, the Connector. Appreciate you. Appreciate y'all joining. Cha Diggy. Appreciate you. She was in there hanging out. Chan Black is golden. Appreciate you. Daniel Berry Sports Highlights. What up? What up? Appreciate you joining, family. Indigo Kepra. Appreciate you. Wilma Darty. Appreciate you. Wilma Keller Darty. Let me put some respect on your name. Appreciate you, family. Much love, much love. Leah. Miss Leah. Appreciate you hanging out. Much love, much love. And yeah, so I'll be live tomorrow when it go live. Whenever I get the notification. And shout out to our stream sponsors, Allie and TSC. Appreciate y'all. Much love, much love. Miss D56. Hey, before y'all go. What up, what up? Appreciate you joining. Shout out to y'all. Shout out to everybody. And like I said, after this stream it'll redirect you to the one for tomorrow so you can set your notifications. And other than that, we out. Stay fresh and stay blessed. Peace out, family. Chan Black is golden. Much love, much love. Tia C, Brown Sugar Babe. Hey, Brown Sugar Babe, much love. Y'all have a good one.
Never hated friend or foes. Just a sub to art and not giving a fuck. Chasing down my goals. I self-law am master. Supernatural disaster. Metaphysical reaction. I am the flesh. I am the God. No one at the lab on lockdown.
Oh yeah, shout out to No One too. I know No One had to go spend some time with his family. Shout out to you, No One. He was here earlier. Appreciate you showing up. Much love.
Come and tap in the most interactive. I am the flesh. I am the God. I am the flesh. I am the God. Tap in, being gone, flesh skin, every rap in. If you like us, gon' get the lights up. So you can share, tell them pack in. Feeling left, right, front to the passenger side. It's right here, the premiere. How you know? Cause them boys brought me to the line. Wanna talk about it? Hit the link.
Not sure if he gonna be guilty or not, but the longer the deliberation, the better that looks for the suspect, or for the person that's on trial. So I guess we'll see. Much love, family. Peace out.
What you mean? Just watch the rise. Watch the rise. I am the flesh.